My lord, on 12th September, the election of my lord, the cooperative of port trust, my lord, held. And one of the entire election at the instance of a very powerful person was totally rigged. And my lord, the counting process was also rigged. My lord, there is a direction pass. The CCTV camera, which is already there in the polling station, that has to be covered up. My lord, this situation is such. My lord, the urgency is, my lord, if the board is formed, my lord, my reputation will become infructuous. So, my lord, I am seeking leave, my lord, if lordship is gracious enough to take up the matter at 2 or 2 at 2 p.m. today.
The election was conducted on
12th September.
12th. Today is the 14th.
Today is 14th.
And the board will be formed very soon, possibly.
That is why, my lord, I am disturbing.
Is the election commission a party over here? Cooperative Election Commission?
Yes.
You serve a copy upon Mr. Srijan Nayak.
Srijan Nayak, lordship.
Right?
Lordship.
And are you aware who is appearing for the society? No. And the state you serve copy upon the AOR also. This is the appellate side, the GP's office. File it in the GP's office. Very well, you come. Not today. Let it appear tomorrow. We will see.
Lordship, I am
subject to Lordship's kind sanction, Milord. Item number 2758. Well, it's a case of appointment. My lord was kind enough to direct the authority to provide the appointment. Thereafter, my lord, the municipal authority, they preferred an appeal. My lord, thereafter, my lord,
matters were there.
Yes, are already disposed of. Another matter, my lord, they have affirmed the affidavit, conceding that the appointment will be given. Let it appear under the heading to be mentioned. Item number 2758.
Monday to be mentioned. 2758.
My lord.
Give notice to the
yes, Lord, with consent, Lord, municipal authority.
Yes. Tuesday. In that case, Wednesday.
As you lordship. As you
lordship. My lord. My lord, may I be permitted to one leave, my lord? Matter relates to, my lord, the formation of a Uposomiti of a Panchayat, my lord. The Uposomiti has been formed, my lord. My lord, totally, my lord, they do not allow the Pradhan and 12 member, my lord, on the formation. And on the basis of the member of the Uposomiti, now the Sanchalok will be elected, my lord. The date of election of Sanchalok is 22nd, my lord. I am challenging, my lord, that election, my lord, hold by which the Uposomiti has been formed, my lord.
20th, it will appear, serve notice.
Yes, my lord.
May I have a lordship?
Urgent motion.
May I have a lordship kind leave to mention, in this matter, your lordship has passed in direction for affidavits, which has not been complied with by the Kolkata Municipal Corporation, and your lordship has set us to liberty.
Side.
Appellate side, my lord.
All right. Then?
And then your lordship has set us to liberty to mention the matter after the expiry of the period mentioned in the order, which has expired long back.
Very well, give.
Let it appear.
To be mentioned, it will appear.
May I be permitted to mention on contempt application?
For?
For my lord, I am not getting the water supply. I am not.
No, contempt for what? You want it for inclusion? Hearing
inclusion,
what?
Inclusion.
Today is not the date for inclusion.
My lord's kind leave for mentioning, my lord, while filing the matter, my lord, the construction was this, and after service.
What you want? What you want?
Lord, upgradation, my lord.
Oh, sorry, today is not the date.
Unfortunate thing has happened in respect of item number 1546 of monthly combined list. It's a matter where Lordship, the entire plan, which was allegedly obtained by the promoter fraudulently from Vaidravati municipality, that has been challenged, sanctioned plan. And therefore, it's a case of unauthorized construction as a result of which. Now, Lordship, yesterday, the advocate on record got a call from the promoter himself and
from the promoter.
Straight call, and a GD has been registered immediately. Online GD has been registered, and Lordship, kindly take up this matter any day.
No, threat for what?
Threat for that you please ensure the withdrawal of this petition.
Withdrawal of the petition.
Yes.
File criminal case and whatever is to be done, it will not be updated.
My lord, may I be permitted to mention this matter, my lord? This is an application which we need to file by taking leave of my lord so that we can move it at 2, my lord. This is with regard to Somen on the matter which is listed before my lord today. My lord, what has happened is, my lord, will kindly remember the last date when we are submitting our report on behalf of ED, my lord. There was an allegation that certain files were downloaded when we are conducting. Now, after that, my lord, a GD has been recorded by the police station. Now, subsequently, initially, a CRR number was filed with the coordinate bench of this honorable court, and this matter was raised there. the honorable coordinate bench of this honorable court said that those will not be taken into evidence and we have not also seized them. But now what the police is doing, cyberware, that they are continuously harassing our officers by sending letters or wanting them to come where, so my lord, this, we need to move an application so that we can get some protection from my lord.
But then, do you think that the this court will be the appropriate forum
My lord,
to?
my lord, it is, my lord, because my lord will remember, we had, you know, the honorable apex court in its order said that all applications has to be filed before my lord. And the interim, then the protection which was given prior to starting this investigation was given by this honorable court's coordinate bench, my lord. So, my lord, there is a.
But then there is a judicial order, not that this is any other order or the
My lord, this is
application.
no
is filed
judicial
for-
order, my lord. What has happened, my lord? The day, my lord, when we conducted the search,
Yes.
allegations were made and a GD, because we are protected by the order of this honorable court, before lodging an FIR, leave will be taken. So they could not lodge an FIR. What they did was they entered a GD number, a general diary number, and treating that general diary number, they are going on with investigation. They are sending us emails, asking questions. And my lord, when this matter, this issue has already been settled by a coordinate bench of this honorable court, where they challenged, they took out an application that it
Very
is.
well, you file the application.
My lord, will
Let us
kindly
see.
take it as urgency, my lord, because it is basically deterring our officers. My lord, will kindly see. Here, my lord, it is,
Matter is there in the list.
my lord, it is in the list, my lord.
You file it.
My
Let
lord.
us see.
My lord, may I
I'm
beg
great.
pardon, my lord, wrongly, my lord, I said, my lord,
My lord,
22nd.
kindly direct, my lord, the court
Date,
officers will grant.
date is, my lord, date is, my lord, 19, my lord,
19th.
19,
19th is Tuesday.
Tuesday, my lord. Monday, my lord, I can.
Mr. Trivedi,
Yes.
possibly you are to file in the department, leave will not be required.
My lord, I will file in the report, but they will not take it in the department, my lord, because the files are, my lord, is lying with my lord.
No, the file will be sent here. It will be forwarded to this court. You mention the courtroom number so that the file can be forwarded.
My lord, we shall.
19th is the
My lord,
date.
19, my lord, kindly pardon me, my lord. On Monday, my lord, I can.
Then Monday, 18th.
18, my lord. Get,
Lord, if I may have your lordship slip to mention, my lord. Item number 507 of today's list, your lordship, it's a municipality matter regarding a tender of the Howrah Municipal Corporation. The lordship had allowed the leave for moving it up into the urgent motion on the mentioning date, my lord. We have been removed from the work on 31st of August and somebody else has been put into the work and illegally the tender has been given. It's a very urgent, otherwise I would not have
No, but
disturbed your
then
lordship.
when you filed the writ petition,
My lord, it was filed on 1st of September.
was the cause of action different? It's
Well,
the
when-
same cause of action.
It's the same cause of action. It's continuing. We had specifically pleaded, your lordship. I will show your lordship if your lordship allows.
Which
My lord.
item?
My lord, item number 507, my lord. Put this list.
507, please upgrade as urgent motion. Give notice to the other side.
My lord, I am very good.
May I be permitted to mention one matter that your lordship presided on 4th of September? Your lordship, only small indulgence, as the names of the advocate of the state were not recorded in this order.
Please give.
Kindly was mentioned on original side matter. But this is the tender matter. This was heard by your lordship when it was submitted on behalf of the corporation. Mr. Ghosh was appearing. Now that they are not proceeding with the tender right now. Now that everything has been done, the technical bid has been opened, the financial bid has been opened. Now, if the third party interested state, entire writ petition will get infractions. So, if your lordship kindly takes up any day,
Hearing
appearing
order.
as item 14 in today's list,
Item 14,
Yes.
parking
Yes,
circular.
parking matter.
Please wait. If you want, I can release it. You can get
No,
it. heard
let it
before-
remain in the list.
No, because in that case, it will be difficult.
The constitution of the Indian matter. Now, I am required to file a supplementary to the supplementary bill.
So if you are required to file, you file it. Who is stopping
Then
it?
in that event, could it be taken up today at 11:20?
No. I'll call the list serially. Please call the list.
Obligement.
My lord, I appear on behalf of the petitioner. My lord, your lordship was pleased to pass an order on 16th of May 2023. And thereafter, it was subsequently extended by the coordinate bench till 18th of September. My lord.
Where is your reply?
It's ready.
Served?
Served.
Yes, ma'am. Well, affidavit in reply filed in court today is taken on record. Stop. Now it has to be heard. What is the position? What is the matter about?
My lord, your lordship kindly takes up your lordship's order 16th May 2023. It is regarding the issue that when the special officer has permitted for regularization upheld by the commissioner,
can the mayor direct for review or not? That was the sole point your lordship was deciding. Kindly takes up page 2 of your lordship's order, my lord, previous order. Special officer granted the regularization that was upheld by the commissioner, subsequently placed in the MIC. The mayor directed that a review should be given. We challenge that, my lord. Your lordship was pleased to restrain them.
The matter is required to be heard. List in the monthly list of December. Interim order that is subsisting in the matter is extended till 22nd December or until further order, whichever is earlier.
Grateful, ma'am.
Well, I appear for the.
But I appear for the
continuous, my lord.
petitioner, my lord.
My lord's order has not been carried out.
Has
because
not been.
No, but because I'm told, my lord, the executive engineer who was my interested at the material point of time, he has been transferred. The other gentleman who has come in the office, my lord, we act as such, my lord, he was not aware of the fact. When we communicated the order, when he said that about this order, we have told them that it is to be acted upon immediately. Your lordship, my lord, kindly grants me some time and it will be done, my lord.
The
within a month.
last order was passed on 7th August, my lord.
That's right, my lord. I admit, my lord, that.
The original order was passed 21st of September 22.
22.
1 year has elapsed.
Long past.
Even the inspection has
I
not been
will-
done, my lord.
Why will the officer concerned not taken to task?
Well, I cannot say
Executive
anything,
Engineer
my lord.
Civil Bureau 9. Because they do not understand and they do not follow what the court requires them to do,
That I do admit, my lord. I do.
right?
Yes, my lord.
So they should be taught what is their duties and responsibilities and how the court's order is to be acted upon. When was this person, Shaurindra Mohan Ghosh,
Yes.
transferred?
Well, I have not, my lord, yet.
Right now, Shaurindra is not there.
Surrender is not there.
Somebody else has come.
Yes, somebody has.
And what is the date of joining? You will not know it.
About my 2 months back, I understand, my lord, from my lord.
2 months.
My lord.
That means the person concerned was there till at least June or July,
June, July, might,
right?
might.
So this person should appear in court on the next day. Please come. Learned advocate representing the
এখন কি আছে?
alleged contemner submits upon instruction that Shaurindra Mohan Ghosh,
দেখি ওটা।
the alleged contemner, has since been transferred and a new incumbent has joined as the executive engineer, civil, Bureau 9. Stuff next. Let the present incumbent be impleaded as party respondent in the instant contempt application. Stuff. Paragraph, the order of the court is yet to be complied with. Stuff next. The alleged contemner Shaurindra Mohan Ghosh is directed to remain personally present in court on 28th September 2023. Stuff. The present incumbent is directed to take steps for compliance of the direction passed by the court on 21st September 2022. List on 28th.
চুলেটাই করুন।
Get-
সে order মধ্যে যে clear আছে।
Leave may be granted, my lord, to my lord, they impede the
Yes, yes.
বললো তো, দর্শক বললো তো।
Are you aware of the name?
নামটা বলুন।
Get the name.
কি নাম আছে?
Lord, I am appealing for the petitioner, my lord. This is the application for the implementation of the demolition order, my lord. On the last occasion, your lordship was directed us to serve the state respondent, my lord. Your Your Lordship, I appear on behalf of the state. I'm apologies for appearing virtually, Your Lordship. On the last occasion, Your Lordship was pleased to serve upon the state. I am for the state. I have instructions that it's a G+5 storied building, fully occupied with tenants and occupiers. We are already in process of evicting them. Kindly gives us 10 days. We can file a report, and the building will be completely vacant or vacated.
But I have instructions to appear for the respondent number 10, I believe. But no copy has been served on me. But again, on instruction, I say that we have checked up the affidavit of service from the court's file. Lord, there it says that it is served on us. But I don't know whether my lord has been informed about that or not. But the affidavit of service says it is not served. Let me have a copy of the writ petition, my lord, and come back to your lordships.
My Lord, we have served, my Lord. My Lord,
Has it been delivered? Have you checked up?
Your Lordship was directed us
So it
to.
is recorded in the order that it was sought to be served, but it has returned unserved, that no such person is found in the address. That is recorded in the court's order.
My lord. So now,
But then if your client is not there at the address or not found at the address, then what can be done?
my lord, the service could be affected if it is sent, my lord. If it, my lord, I am not going into that. Let me have a copy of the writ petition and come back to your lordships, my lord.
Yes, yes.
My Lord, the respondent number 10, my Lord, have filed as SLP and Supreme Court, my Lord. My Lord, they have rejected that application was rejected, my Lord.
Whatever you got to say, you say.
কপি দেবেন এসএলপি করেছে বলে টাইম এসএলপি করাটা তাহলে ভাই আমি কি একটা কপি নিয়ে কোর্টে আসবো না
Learned advocate representing the state respondents submits upon instruction that the G+5 storied structure is fully occupied and the police is taking steps for vacating the same. Stop. 10 days time has been sought for implementing the order passed by the court. Stop. Next. Learned advocate representing the respondent number 10 submits that copy of the writ petition was not served upon his client. Stop. Let a copy of the writ petition be served upon the learned advocate representing the respondent number 10. Stop. Let the matter appear in the list on 5th October. A report shall be filed
Lord,
both by the police and the
Lord, that would,
corporation on the adjourned date.
Lord, that would mean that
Your-
Lord, your lordship has directed them. They will now comply and come.
So obviously, this is for implementation.
Your Lordship,
I have,
Your Lordship,
without hearing me, kindly do not pass that order, my lord. I have something to
Right.
inform your lordship.
For purpose of complying, you are required to be heard.
Yes, my lord. I have filed an appeal to the building tribunal, which is pending.
Your
I have
Lordship, one indulgence.
Tribunal.
10 orders from there.
Lord, they have annexed the order of dismissal of the appeal, did not annex the order, my lord, of the restoration of the appeal. So, my lord, you're on the teeth of your lordship's order, my lord, they will now tomorrow evict us. Lord, kindly allow me to come back and apprise your lordship, then my lord direct them to implement.
No, you can, if you can show here and now that there is no order,
Lord, I don't have a
Of
copy of the writ
demolition.
petition. I can show that, my lord,
then you are aware of the facts of
Lord,
the case.
I have availed the statutory remedy before the tribunal.
It is you who know it.
Yes.
Have you informed to the court that you have
Lord,
availed the
next date is
statutory-
on 21st of September before the tribunal.
Whatever you
Lord,
have
kindly
Your
got-
Lordship, one
21st of
indulgence.
September and allow me to come back and apprise your lordship of the status. But my lord, if in the meantime the police, my lord, as the state lawyer has said, my lord, implements the order, then my lord appearance or my lord coming back to your lordship, my lord, would be absolutely futile. But kindly appreciates, my lord, whether there is a illegal construction, the tribunal will decide whether it is illegal or legal, because the appeal is pending before the tribunal and 21st is the date fixed. Kindly allow us to come back after that, my lord, on 22nd and inform your lordship whether we have been able to get any order or not. Then my lord, my lord, I'm kindly appreciates this, my lord. But in the meantime, if they implement the order, then my appeal would also go, my lord.
Why don't you obtain orders prior to that?
My lord, the appeal got dismissed and then it is restored. I am on instruction again saying I don't have a copy of that.
No, it has been restored.
Restored.
You obtain stay orders from them.
21st is the date. 21st.
You can prepone it.
Extremely difficult. They are in the tribunal. It is impossible. Not
And it is
today-
very easy over here. Since the courts are every day available, So it's very easy.
Not
And
easy.
this
Your
was the
lordships are
tribunal.
lenient. Your lordships are lenient and your lordships are here, blood. I tell you,
And
lordship,
that is
this,
the reason the court should become more strict.
blood, the
court
tribe,
should not be
these
so
tribunals, I
lenient.
tell you, lordship, these tribunals,
No,
blood,
don't.
then blood, if,
Whatever you've
blood,
got to
today,
say.
if I go and file an application in electricity, I get a date after 3 years. In SAT, I get a date after 2 years.
No use mentioning here.
Lord, kindly, Lord, keeps it on any day, Lord, on 25th, kindly keeps it. Let us come back. Lord, if they implement it by this time, then everything will become futile. At least let me try my luck.
কবে বললাম?
5th of
5th of October.
20
5th of October, I'm keeping it.
in the meantime, that report portion, they will implement it. They done that. I
Listen,
do not direct them that.
22nd, you say.
21st.
21st is the date. You obtain an order. You can always intimate the authorities that this is a
By
stay order.
that time, they will evict it.
By
Lord,
that time, they will.
Kindly
they
see
will be
what he has
evicted.
said. He said within a week, he will remove everybody.
Yes, today is 14th. So
He
week
said
comes
that.
27th, 21st. Please,
Kindly
let
do
us
not
see what happens.
mention only that the report and all that. Not kindly
Let
do
us
not.
see. Let us see.
Your lordship, can be fixed on 4th. Just one indulgence, your lordship.
4th of
On 4th
October.
of yes, your
Yes, 4th of October.
Not for report only for blood assessment of the situation. Only that portion what I beseech your
If
lords.
you obtain orders, they will not work at all. I am very sure. They'll say that this is the order. We cannot work. Yes, call the next matter.
Grateful, your lordship.
Well, I am for the private respondent. Law should direct it to inspect and file a report. Well, the report copy has not been circulated.
Has it been inspected?
Yes.
And was it inspected upon notice to all the parties? Everybody is aware of the inspection? Both present. Give a copy. Please circulate copy.
Well, may I go through and
Yeah,
come back?
go through and come back, please.
And logically, give me some time. I mean, I don't know what is there. Whether I'll take exception or the petition will take exception, we don't know. So give us 2 weeks and let it come after 2 weeks.
Report filed by the executive engineer within bracket building. Achha, executive engineer within bracket civil/building. Borough 7. Signed on 12th September 2023 is taken on record. Stop. Copy of the same circulated amongst the parties. Stop. List. 3rd of October. 3rd of October. The parties will be entitled to file exception in the meantime.
I'm grateful, my lord.
Lordship, kindly see, my lord, the order dated 10th August, when Lordship directed the Kolkata Municipal Corporation to come with a written instruction. What happened, my lord? The work order issued in the year 2017. My lord, the commissioner certified the work has been completed. They are satisfied, rather. Joint commissioner asked for fund from the state authority. Fund once was there and then returned. And my lord, 2023, my lord, I am yet to receive any funding from the Kolkata Municipal Corporation, my lord, claiming themselves with a
Let me see.
written instruction.
The order was passed regarding the payment part, my lord. I understand, my lord. A letter was issued to my land payment for submitting certain papers and documents.
What paper, my lord?
That is, my lord, I'm told.
What paper, my lord? No specification is there. Everything is over. This is the second round of litigation. First round of litigation, my lord, when they are sitting tight, I move before this honorable court. Honorable court directed to consider each and everything. Then they have come to a conclusion, my lord. Certain works have been completed properly, certain not, all these things. Though, my lord, the work order is over. Work order I have received. My lord, the commissioner certified the work is completed. Now, my lord, what remains, my lord? What paper they are asking for?
1 minute. You have a copy, must be having. a
Yes,
copy.
my lord, I have received that letter, my lord. I have immediately written a letter addressed to them, my lord, that is yet to reach to them, my lord. I'm showing, I have prepared one, my lord, supplementary affidavit also.
The second paragraph of the letter mentions that you are requested to take necessary action and submit necessary documents.
What necessary document, my lord? Yes, ma'am.
Strictly in compliance with the order of the special municipal commissioner.
My lord, what document, my lord?
I don't know, no, municipal commissioner. passed
No, I'm
certain
just
of
going, my lord, but
special-
kindly see, well, that is the impugned order before this honorable court. My lord, they are also, my lord, they have prescribed for
18th
part payment.
18th January 23.
Lordship, kindly see, my lord.
Possibly, my lord, bill needs to be submitted because the payment to be made, that are the,
Bill has not been
no, my lord,
submitted.
because, my lord,
Yes,
the-
my lord.
how
Kindly see,
much
my lord, the
amount to be
situation.
paid, because on the basis of the order which has been passed by the authority, in terms of lordship's direction, my lord, he is asking for payment on such basis. Therefore, the bills have to be, my lord, according possibly, my lord, I don't know exactly that is the reason they have, my lord, asked for
But
the.
your letter should specify what is the document that you are requiring. Is anything mentioned in the letter?
No, my lord.
Please check up. I do not find anything that requires to be submitted.
But that I'll check it up. But I possibly when I'll inquire of that. But the two places the work has been done. They agreed to pay the authority of
Please come.
first time the directions.
My lord, kindly, my lord, visualize the situation. My lord, in the month of August, 10th August, this order was passed before my lord, lordship, my lord, circuit bench. And
By a communication dated 21st August 2023, the executive engineer within bracket E, electricity department, requested the petitioner to submit necessary documents in compliance with the order of the special municipal commissioner number 2 dated 18th January 2023. Stop. Next. The specification of the documents required to be submitted by the petitioner is not mentioned in the aforesaid letter. Stop. Next. Paragraph. The order of the special municipal commissioner dated 18th January 2023 does not mention about any document required to be submitted by the petitioner. Stop. Next. Paragraph. If the executive engineer intends to have copy of documents for the purpose of releasing payment in favor of the petitioner, then the details of the of the required documents ought to have been mentioned in the letter so that the petitioner could have forwarded the same to the authority. Stop. Paragraph. The executive engineer, in a vague communication, mentioned about submission of necessary documents without disclosing the details thereof. Paragraph. The said executive engineer is directed to immediately intimate the petitioner the details of the documents required for releasing the payment. Stop. The petitioner shall be communicated. No, the petitioner must be communicated about the necessary documents within 22nd September 2023. Stop. Let the matter appear in the list on 5th October 2023.
instead of executive engineer, direct, my lord, DG lighting, my lord. So, my lord, they are all,
He is looking at the
my
matter.
lord, kindly see, my lord, dragging, my lord, not looking,
We will see
simply
how-
dragging.
how to put them in the right track.
Dots.
আমরা তো লড়তে পারলাম না।
তখন একটু irritate হয়ে যায় লোক। Deeply up.
I'm for the petition. Lordship, this writ petition, your lordship, was filed only for the purpose of providing your lordship the inquiry report. After filing this writ petition, your lordship, they have provided us the
So
your
the
lordship,
petition has become infructuous.
this has become infructuous, your lordship, that is already recorded on the order dated 6th of September 2023.
But your lordship, the honorable court didn't have the determination, so your lordship.
Taken up by other
Honorable
coordinate
Justice
bench.
Bhaskar.
Other coordinate bench, it was taken up. They were wrongly filed before that bench. That was recorded, of course, my lord,
Already.
regarding supply of the.
So on that basis, your lordship, this writ petition may be disposed of.
Very. It has been submitted by the learned advocate representing the petitioner that the relief sought for by the petitioner has already been granted by the respondent authorities. Stop. Next. The cause of action for filing the writ petition does not survive at present. Stop. Next. In view of the above, the writ petition stands disposed of.
I'm grateful.
Next
Lordship, I
matter
am
is
for the
also the same.
No, your lordship. Now, your lordship, what happened, your lordship, after giving the inquiry report, they have set it aside. Lordship, may I, your lordship, show your lordship the order, which is under challenge. May I file your lordship the affidavit of service? Mr. Ghosh, your lordship is appearing. Lordship, kindly take your lordship page. The order passed by your lordship, the Municipal Commissioner and Disciplinary Authority, page 100.
Yes.
Lordship, kindly sees the order dated 4th of September 2023 in exercise of the powers conferred by sub-regulation 4 of regulation 9 of the Calcutta Municipal Corporation Service Classification Control and Appeal Regulation 1985. Shri Chaitanya D. Sarkar, formerly Special Commissioner of Revenue, Commercial Tax Government, was appointed as an inquiry officer with order dated 24th of November 2021 to inquire into the charges framed against the said Partho Chongdar, erstwhile posted at Asphaltum Department KMC with a charges dated 24th of November 2021. Whereas in partial modification being number such and such, Shri Vishwajit Majumdar KMC was appointed as inquiry officer, as Shri Chaitanya De Sarkar has returned the file before the completion of an inquiry upon submission of the application for resignation from his engagement. And whereas it has been found that the inquiry officer Vishwajit Majumdar has not specifically dealt with each of the charges by expressing his definite finding on each article of the charges imputation and his reasons thereof. Therefore, it is ordered that the inquiry report dated 10th February 2023 submitted by the inquiry officer Vishwajit Majumdar is set aside. However, in the partial modification of the earlier memo dated 31st of March 2022, Shri Shumanta Kumar Bhomik, Chief Municipal Auditor, KMC is appointed as inquiry officer to inquire de novo into the charges since framed against the said Partho Chongdar Assistant Engineer, EID, erstwhile posted as Asphaltum Department, KMC. Shri Niyogi has already been appointed as a presenting officer for presenting the case on behalf of the disciplinary authority. May your lordship indicate, your lordship, now the brief facts, what has happened in this matter.
Show me the memorandum of charges.
Lordship. Lordship, kindly take your lordship page 44. And your lordship, the article of charges starts from page 45.
Where from did this sum come? 3 crore 26 lakh?
Lordship, this is an, your lordship, the figure, your lordship, they have calculated. I could not understand, your lordship, this figure where comes. Then no justification.
No justification.
Nothing. Lordship, may I indicate what has happened? Lordship, they
What does
refer.
his wife do?
Wife, your lordship, she is an independent lady. She is, your lordship, as a company and working there as a
Company?
director.
Company, what is the purpose of the company?
Purpose of the company, your lordship, is to provide, your lordship, manpower.
Manpower.
Manpower, providing manpower. That is the nature and the business of the company.
Provided manpower for what?
For different companies, your lordship, nowadays, your lordship, the providing manpower to the private companies, your lordship, is very normal. Your lordship, they don't take the employees. What happens, your lordship, the companies form, and your lordship, they usually give the manpower so that the companies, your lordship, they won't be a direct employees of them. So this is, your lordship, very general nowadays in your lordship, the metropolitans. Your lordship, this type of companies are formed.
Show me the order of the
Inquiry officer.
erstwhile inquiry officer.
Yes, your lordship. Now, your lordship, in 2023, your lordship, when I filed the writ petition, now, your lordship, they have given me this inquiry report. Lordship, kindly take. Lordship, page 85. And then, your lordship, they have given me from page 86. This is a communication, your lordship, from Chief Manager, Personnel, communicating the inquiry report as well as the order. Page 85 and, your lordship, page 86, your lordship, this is the inquiry report they have given me, which is dated sometime in 10th February 2023. And, your lordship, findings, your lordship, will get at page 96.
Shukanto Niyogi was the presenting officer at that point of time also.
Yes, your lordship.
This time also, he is the same inquiry
Yes,
officer,
same
the presenting officer.
presenting officer. May I just check, your lordship, once? Niyogi Shura.
Yes, Shukanto Niyogi, deputy
Yes.
personal officer, is there. He remains the same.
Page 42, your lordship, will get page 42, the same inquiry, presenting officer, Shukanto Niyogi.
Yes, here also 96 presenting officer
Yes,
is
yes.
there.
And the inquiry concluded, your lordship, in August 2022.
A person who is earning only 81 lakh of rupees per year, how does he purchase such a big flat and get such a big car and all these
Lordship,
things?
everything is the name of everything.
Of wife.
I understood. Everything, your lordship, is in the name of, your lordship, the wife.
Wife.
Volvo car is in the name of the wife. And, your lordship, the inquiry officer, your lordship, found that.
So
I have
the
given-
wife is the conduit.
No.
Then
Lordship, she is earning money, balance sheets, ITR, everything has been given to the
everything is
corporation.
there. Yes.
We have provided them. This is not a case, your lordship, where I'm running away, your lordship, from the corporation. Lordship, may I indicate vigilance? They referred my name to vigilance. I participated there. Once I participated there, answered all the questionnaires. Now, your lordship, the vigilance, your lordship, without passing any order, referred my name to the disciplinary proceeding authority. Now, KMC, your lordship, disciplinary authority, your lordship, suspended me, gave me charges during the pendency of the inquiry.
You are still under suspension?
No, they lifted the
Very well.
suspension.
Thereafter, you are working and
I'm
the
working.
inquiry is continuing.
Inquiry is continuing. Inquiry concluded, your lordship, in August 2022. Now, what has happened? After the conclusion of the inquiry in August 2022, they have not taken any disciplinary action against me. Suddenly, in August, your lordship, 2023, your lordship, the Anti-Corruption Bureau, your lordship, approached my house, seized all the papers, and from 8th August, your lordship, I found that, your lordship, they have referred my name. Your lordship, prior to that, they have referred my name to the Anti-Corruption branch. Lordship, there, your lordship, I applied, your lordship, a certified copy, and all seizures lists I have obtained. Now, what has happened? The moment, your lordship, I got it, I applied before them. Kindly give me the inquiry report, which has been passed against me or in my favor. I don't know. Now, what happened after?
What is the immediate relief that you are seeking here?
I am immediate relief, your lordship. I am seeking that as per this particular regulation, your lordship, they don't have any right, your lordship, to set it aside, your lordship, the inquiry report, your lordship, de novo. First, my first point, your
What
lordship.
is that?
Yes, your lordship, kindly. Lordship, they have to show some regulations.
No, but
Not-
then what can be the interim order in here? I do not
Stay of the
follow.
proceedings before the new inquiry officer. Inquiry report has been given. No notice has been given and set it aside, your lordship. Inquiry report has been set aside. Lordship, kindly sees, your lordship, the order has been passed, and your lordship, the proceeding has already started. And your lordship, they have given me 3 months time to conclude it.
3
Page-
months we have time, so let them file their opposition. We will see what is to
But
be
in
done.
the meantime, your lordship, I need a protection.
Because
What type of protection?
kindly sees your lordship, once your lordship the regulation. There is no provision, your lordship, in the regulation that they can do it de novo. Lordship, kindly take internal page 20, your lordship. Internal page 10. Regulation 9.
Yes.
Now, after the completion of the inquiry, a report shall be prepared and it shall remain the article of charges and the statement or imputation of misconduct or misbehavior, the defense of the corporation employee in respect of each article of charges, an assessment of evidence of each article of charges, the finding on each article of charges and the reasons thereof. Now, your lordship kindly sees. The disciplinary authority shall consider the record of the inquiry and record its finding on each charges. If the disciplinary authority, having regard to its finding of the charges, is of the opinion that any of the penalties specified in clause 1 to 3 of the regulation 7 should be imposed, it shall pass appropriate orders on the case, provided that in every case in which it is necessary to consult the commission, the record of the inquiry shall be forwarded by the disciplinary authority to the commission for advice, and such advice shall be taken into consideration before passing orders. And thereafter, your lordship kindly sees clause regulation 12. If the disciplinary authority, having regard to its finding on the charges, is of the opinion that any of the penalties specified in clause 4 to 8 of regulation 7 should be imposed, or where the commission recommended in any of the cases referred to it under sub-regulation 11, one or other of the penalties specified in clause 4 to 8 of the regulation 7, and the disciplinary authority agrees with the views, it shall furnish the corporation employee a copy of the report of the inquiry authority and a statement of his finding, together with the brief reasons for disagreement, if any, with the findings of the inquiry officer, and give him notice stating that the punishment proposed and the ground therefore, and calling upon him to submit within a specified time such representation as may wish to make on the punishment proposed only on the basis of the evidence adduced during the inquiry. So, your lordship, there is no scope of the de novo proceedings or setting aside of the inquiry report without giving me any notice, no hearing. So clear, your lordship, is a violation of the principles of natural justice. Today, what I am on, today, good, bad, indifferent, your lordship, there is an inquiry report in my favor. On the basis of the inquiry report, your lordship, they have to do, your lordship, the disciplinary proceedings. There is no provision in the regulation which authorizes them, your lordship, to do this de novo proceedings.
Yes.
I have submitted to your lordship in service jurisprudence. In service jurisprudence, the disciplinary authority, disciplinary proceedings has not even been concluded. The inquiry has been concluded. As per my non-specified contention, that report is submitted to the disciplinary authority. Disciplinary authority has the power to go into that, and my understanding has referred to the particular regulation. That regulation speaks of each finding on each article of charge specifically to be arrived at by the inquiry authority. If the disciplinary authority considers that each article of charge has not been properly addressed and the findings is not there, then the disciplinary authority may either two courses are open to him, either he comes to a different finding on each of the article charges, or he may refer the matter to the disciplinary inquiring authority, or appoint a new inquiry authority for due inquiry. I am asking to myself, what is the prejudice to cause to him? He is saying that his inquiry report is in his favor. If it is favor in one's report, then it may be favored by the other report. Therefore, he has all the authority to contest that for the proceeding. Therefore, he might appear before the inquiry officer and allow us to conclude the proceeding.
The disciplinary authority could have rejected the inquiry report after hearing the petitioner. Why, without giving him an opportunity of hearing, was this done?
That your lordship can say that because the primary consideration is of the authorities, of the disciplinary authority.
Certainly.
Now, if your lordship can appreciate this thing, if the different findings is arrived at by the disciplinary authority, there is no reasons to hear the petitioner. If the disciplinary authority, my lord, considers their inquiry report, and if he says, if he, my lord, comes to, here in this case, the de novo inquiry has been directed to be made.
How can that be done without giving him an opportunity of hearing? It's only to this limited extent. The court is not going into anything else. Only to this extent, there is an inquiry report. Good, bad, indifferent, in
My lord.
whose ever favor it may be. But then if it is set at naught, won't an opportunity of
My
hearing
lord
be
is
given?
considering that had it been done by the disciplinary authority
After
himself, disciplinary authority himself, my lord, the different finding, that's a different issue.
Yes,
But when he is asking for de novo inquiry, then
right.
the person incumbent ought
Ought
to have
to have been giving an opportunity of hearing.
the takes it, my lord, next week, my lord, any day, my lord, take instructions, my lord, and submit well accordingly. Possibly, my lord, that could be done according to me, my lord.
Yes. The order dated 4th September 2023, passed by the Municipal Commissioner and Disciplinary Authority by by appointing fresh inquiry officer for conducting de novo inquiry into the charges framed by the petitioner. By setting aside the earlier inquiry report dated 10th February 2023 is impugned in the present writ petition. Stop. Specific case of the petitioner is that the inquiry report was set aside without granting any opportunity of hearing to the petitioner. Stop. The same is in violation of the principle of natural justice. Stop. The petitioner ought to have been afforded an opportunity of hearing prior to setting aside the report of the inquiry officer. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation seeks time to take instruction in the matter. Stop. On such prayer, list on next Thursday, 21st of September. And in the meantime, you are not doing anything.
I'm grateful, Your Lordship. Kindly indicate, Your Lordship.
No, Mr. Ghosh is there. It will appear in the next list.
See-
3 months' time has been given for completion of
Once
the
he is here,
inquiry.
Your Lordship, at least we are safe.
Yes, yes, don't worry.
So only one indulgence, Your Lordship.
Yes, please.
Mr. Shomo Mujumdar, Your Lordship, is leading me. Can I give his name, Your Lordship? Your Lordship, Your Lordship.
The proceedings of court are live streamed. So names cannot be
My
incorporated
duty,
in
Your
that
Lordship, my
manner.
duty.
না, না,
আর হবে না, আর হবে
না, না, হবে, হবে, একটা হবে। I'm appealing for Kolkata Municipal Corporation.
My lord, I appear for the petitioner.
Before the petitioner starts, indicate, my lord, all parties have not been impleaded. I have not been impleaded. Notice has been served and the writ petition was served on Big Fat Belly, the restaurant, which from the petitioner's own application, it appears that they are aware that somebody else is there. Complaints have been made against all the residents. None of them have been made a party.
Residents
All the residents
of
of a particular building.
My lord, in this petition, we are seeking a specific relief against respondent number 8, that is Big
Let
Fat
me be
Belly.
added in the writ petition. I don't,
Respondent number 8.
They are not
Respondent number 8.
respondent number 8, my lord.
Jayanta Chatterjee. Very well.
7 and 8, my lord.
I am appealing for Kolkata Municipal Corporation. Well, we have held and spot inspection.
1 minute. Who is appearing for 5 and 6? Varun and my Big Fat Belly.
I am Big Fat Belly, but I purchased it from someone else. I don't want to
But
scuttle
then
the
you are a party. You said you are not been
Big Fat
implemented.
Belly, act me. Big Fat Belly has sold the property to me and gone. Big Fat Belly, your lordship would recall, was a restaurant. So name Big Fat Belly is still appearing there.
They've given it there and gone. I don't.
My lord, we are not aware of that.
You?
We are not aware of that.
Let me
If
just finish. It's okay.
If the developer,
I don't want to scuttle the hearing. I have a copy of the writ petition by hand. If they can just add.
so my lord, then
That's
we
all.
can argue it.
Yes, what is the matter?
Yeah. My lord, there was a development agreement dated 16
Not you.
for the petitioner.
Yes, who is the petitioner?
I'm the legal heir of 50 of the owner of the land.
Legal heir of the owner of the land.
My predecessor was the owner of the
Yes.
land. There was a development agreement dated 16th October 2007 for the construction of a ground plus four-storied building. Building was constructed, the sanctioned building plan was for residential use only. Now, the developer sold, so the allocation was 52% with the petitioner and 48% of the property with the developer. The developer sold a part of the property, that is a small parking space on the ground floor, to Big Fat Belly, where they started constructing a restaurant. Now the restaurant got constructed. Not only are they using it for a commercial purpose right now, which is not permitted, and they did not even send any sort of notice under Rule 26 of the KMC building rules. And furthermore, the constructions they've been doing on the ground floor are causing structural damages to the building. And the main column has been damaged, and you would find that from the photographs from page 58. So, my lord, the KMC has already come in and inspected. Now, the KMC has already locked the premises. Right now, what we are seeking for is that an inquiry be made, one, and a report be filed, and that structure may be demolished. This is attached. My lord, may I just hand over 2 photographs
For what?
to show the damage that's been
Did you lodge any complaint before the corporation?
Yes, my lord.
Where-
We've filed 2 complaints. The first is on 5th May 2023. That's at page 55 to 57. And the second is at 29th October 2023 from 77 to 81.
Very well. What is the corporation stand?
My lord, just one more thing. In the meantime, let them not continue any sort of constructions in the area. My lord, and if they continue, the building may collapse any day.
Please come.
Could I just indicate one thing, my lord?
Sold this property to someone. No. Order number 6 was my tenant, my lord. He left the premises in January. So I sold this property to one Mr. Rajendra Agarwal, State LLP.
Respondent number 5 has sold the property to?
To Mr. Rajendra Agarwal, State LLP.
My lord, we are not aware of that.
State
Sorry.
Rajendra Agarwal.
State LLP.
5 you've sold, 6 somebody else is there.
My tenant who left the premises, my lord, in January. In January 23, 6 left.
Tenant,
6 I am representing. I
Yes.
purchased it from. I'll give that my name.
purchase
Purchased by registered. deed
From?
conveyed.
from?
From the erstwhile owner, not a tenant. From the
He
erstwhile
says
owner.
that
From me, not from me. I have sold it on 19th of April 22.
From 19th April 23, he sells it to X. X sells it to me. I have come in August.
Yes, I got it. 7, what is your stand?
I developed the property as a developer. Construction is completed in
2011.
Completion certificate, final completion certificate is provided by corporation stating that.
So right now you are not making any construction and you are not,
I have sold the development.
Everything.
certificate to different buyers.
very well.
Sale is
8.
completed in 2014.
8 you are representing also. The chairman.
7 and 8. 8 is the
So right now you are no way related with the constructions that has been made. Please come.
Well, may I take your lordship's leave, my juniors?
Could I just take a minute of your lordship's time?
I don't think so. I'll require any hearing from you.
Only one thing. There is a stop work notice that's been issued on me. This is a shop which was there as a shop and commercially used premises. I have the license for that. These are internal repairs that are going on. Anyways, there's a
The
complaint which is on
petitioner
record.
complains of illegal and
it's-
unauthorized construction
My lord, it's absolutely illegal.
at premises number 22, Sharad Bose Road, ward number 69, 408, under jurisdiction of the Kolkata Municipal Corporation. Stop. The petitioner complains that plan was sanctioned for raising construction of a residential building. Stop. The developers constructed the building in the year 2000, prior to the year 2010/11. Stop. The ground floor was sanctioned for car parking space, but the same has been illegally converted to commercial shop rooms. Stop. Paragraph. Presently, constructions are being made in the said premises in such a manner that the structural stability of the structure is at stake. Paragraph. Complaint was lodged before the corporation. Stop. The petitioner alleges that the said complaints were not acted upon. Paragraph. Were you submitting something? Somebody.
I was submitting, my lord, that this space was not, as per the sanction plan, is falling within the meaning of car parking. It was a lobby. My lord, I have the sanction plan. My lord, it was a lobby,
my lord.
it was sold.
Very good. Acha. The learned advocate representing the private respondents denies the allegation of the petitioner. Stop. The respondent numbers 7 and 8 submits that they were the developers of the subject property, and after development of the same, they sold their allocated portion long back. Stop. At present, they are no way connected with the construction that is alleged to be made. Stop. Respondent paragraph. Respondent number 5 submits that the property has been sold long back by the respondent number 5. Stop. The respondent number 6 is also presently not running from the said premises. Stop. The same has been sold in favor of, please put down, in favor of such and such. Acha.
My lord, they were just saying Rajendra Agarwal. It was sold.
That is 5.
Necessarily
I
don't
have
get
5 and he is 6. Next, a report has been filed by the engineers of the Kolkata Municipal Corporation. Stop. It appears therefrom that the corporation sanctioned a residential building plan for construction of G+4 storied building in the year 2007. Stop. The same was modified/regularized twice on 5th May 2010 and 17th September 2011. Stop. Completion plan and the completion certificate was issued on 20th of September 2011. Stop paragraph. Ground floor of the subject structure was sanctioned as car parking space. Stop. First floor was sanctioned as showroom and second to the 4th floor was sanctioned as residential flats. Stop. A portion of the ground floor was sanctioned as entrance lobby for showroom without any walls. Stop. Paragraph. On inspection, it has been found that the 2nd and the 3rd floors are now used as office, changing from the original sanctioned plan. Stop. The entrance lobby for the showroom is covered by brick walls. Stop. There are shop rooms running since few years. Stop. Constructional activity has been found like replastering, reflooring, etc. Stop paragraph. The corporation has issued notice under section 401 of the KMC Act 1980 with intimation to the Baliganj police station. Stop. Further action under section 400 and 416 of the KMC Act 1980 will be taken as per the departmental procedure. Stop. Next paragraph. On hearing the submissions made on behalf of all the parties and upon perusal of the report filed by the engineers of the Kolkata Municipal Corporation, it appears that unauthorized construction has been detected at the subject premises. Stop. The corporation has initiated action in response to the complaint lodged by the petitioner. Stop. Next. The concerned executive engineer is directed to take prompt necessary steps to deal with the unauthorized constructions that have been detected at the subject structure after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop paragraph. A reasoned order shall be passed and communicated to all the parties. Paragraph. The officer in charge, Baliganj Police Station, is directed to keep strict vigil and ensure that construction in any manner whatsoever is not carried out at the subject premises. Writ petition stands disposed of.
My lord, just one request. Could we get a copy of the report?
Whatever is there in the report is reflected in the order. So
Grateful.
separate report is not required to be
Grateful,
supplied. Grateful, man.
Grateful.
Rest of the matters are released.
কি দরকার এটা? But it has come at our instance. My lord, as hearing is concluded. Only one clarification my lord has sought for. If you lordshiply take up your lordship's order dated 28th April 2023. কি আছে তবু? ফাইলটা দিয়ে যায়নি। This is a case where, my lord, you are duly selected, selection committee constituted, we appeared, selected, joined in the service. Thereafter, my lord, at the instance of the minister, our service was terminated.
28th April.
My lord, can you see your lordship's order?
Yes.
Started advocate representing the state respondents commencement argument but does not conclude on the same date. But it has been, he said that he has been concluded. Then the parties are directed to appear the court as to whether, apprise the court as to whether selection committee which was constituted for conduction of the selection process was in accordance with the provisions of the West Bengal Survey rules, specifically rules. Selection committee as selected in the first meeting such and such, though contains the name of the three councillors, but
Out of the three, only two signed the minutes of the meeting. From the final score sheet prepared by the municipality, it appears that the third councillor did not allow any marks. This name of the third councillor is also not appearing in the tabulation sheet. According to the rule, three councillors are required to be nominated by the members of the selection committee. The parties are to submit on the next date as to whether the selection could have processed in the absence of the third councillor. This is Lordship's query. I am answering your Lordship's query, my lord. Under the rules, three councillors are there, but there was no quorum statutorily fixed. If no quorum is fixed, my lord, majority will prevail. And here, factually, yes,
If no quorum is fixed, then the whatever is the resolution that will fall.
No.
If there is no quorum.
Supreme Court says otherwise, that if there is no quorum fixed by a statute, then the
Fixed by the statute.
Yeah, not fixed here. So majority will prevail.
All right.
That I will show to your lordship. And here factually, the lady has not signed the score sheet, but when it was placed before the board meeting of the councillor, she approved the entire selection. That is on record.
No, but then a lot of scam is going on with the municipality
But that is the- probably
recruitments.
this is not under this.
Nobody knows.
I-
The municipalities are involved. What is your stand?
I support the employees.
Which
because we have been
employees?
prudent. The employees came before your lordship.
Yes.
Such allegation in this process.
Nobody knows. Where is the allegation? Where is the state?
State.
Is the state a party?
Yes, state concluded submission.
State is a nation.
My lord, Mr. Talib appearing for the state, you don't like.
So Tali Siddiqui must be assisted by somebody.
I'm not aware of it, my lord.
You may not be aware, but the court can see that somebody's name is recorded in the order sheet.
If management issues, I think there might not be in the panel.
Are you aware of the name of the junior?
No.
Then how do you know that the junior is not there in the panel?
He was supposed to come.
No, he said he is maybe. It is not reached to my lord.
I'm not aware of him, my lord. I guess he was supposed to come.
Don't make all these type of submissions on guesses. The court is looking at some document. An order is there. The persons are out of service. And you take it so lightly. I would require the assistance of Mr. Talib Mohammed Siddiqui. Tell him to come. Yes, certainly now. I'm passing it over.
Here, but that is not the allegation. My lord, I want to say the allegation which was there, the minister who has nothing, no role to play. I have cited judgment for your lordship consideration. The minister has no role to play when the statute provides for a specific provision.
Now everybody is trying to poke their nose in every matter. And nobody knows which is correct and which is incorrect.
Off the record is beneficial for us.
That
My lord is
is,
troubled, obviously.
that
That's
is up
there.
to you. Yes, call the next matter.
I have got
Let
the
me see
instruction.
your instruction and what was the writ petition for?
Challenging the inaction of the tender, my lord. In the meantime, the tender has been, work order has been granted, my lord.
Please come. The petitioner has communicated to his learned advocate that he does not intend to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands dismissed as not pressed. Paragraph. Written communication made by the petitioner to the learned advocate be retained with the records. Extension of interim order.
No. It is marked as extension of interim order, but I
Correctly
do not know at
marked.
whose instance, my lord.
Is there any interim order?
There's an interim order for a inquiry to be conducted by an officer of CID
Yes.
under the supervision of a retired judge, that is my Lord Justice Devi Prasad Dey, His Lordship.
All right.
But my Lord, today I find is appearing under the.
They are
suspension
supposed
of
to,
interim.
they are supposed to file a report.
They means who?
On 20th
So the
of-
heading is incorrect.
20th of July, your ladyship was pleased to direct that let the inquiry be completed and the results thereof in the form of a comprehensive report be placed before this bench within 4 weeks from the date of forwarding order. I understand it must have come for that
Completed.
purpose.
Now, my Lord, in earlier matters, we have seen that my Lord Justice Dey has been pleased to file the report.
One matter which went up in appeal.
Yes, that is MAT 1135.
I cannot recollect
Yes,
the
my Lord,
number, but then
Kashmira Begum.
Kashmira Begum.
There, my Lord, the inquiring authority did not file the report. Report was filed by my Lord Justice Dey.
Yes.
So in this case also, my Lord, we are expecting similar report.
Let me see.
Report directly filed for the court. Yes.
Yesterday, we took up one matter where similar direction for inquiry was carried to the appeal court.
Yes, and that is for the timing in the state,
State.
my Lord, the Honorable Appeal Court is hearing the matter.
Yes. Now this has not been appealed against.
Well, it is a bit different, my Lord. If one kindly takes page 2 of the last order, my Lord. Page 2, the second last paragraph, my Lord. It was the DIG CID to conduct a thorough investigation himself or to appoint somebody immediately below the rank of DIG to conduct the investigation under the supervision.
That
So
has been
I
done.
understand, my Lord, the CID can also, my Lord, come up with a report, my Lord, subject to what Mr. Bandyopadhyay says.
Since it is
Because
under the
the
super.
investigation will be supervised by the Honorable Justice Dey.
Has the DIG CID conducted any investigation?
My Lord, we have a progress report. To be there.
Then please hand up.
But my Lord, only thing is that I'll copy the now. The only thing is that, my Lord, this
Oh,
is
it
also a
mentions
direction in the
justice.
order that the documents to be handed over to my Lord Justice Dey,
Yes.
my Lord, which has been done on 10th of August.
Yes.
And thereafter, my Lord, it has been the verbal direction of my Lord Justice Dey that till my Lord is not pleased to give any further direction, not to do any further work with regard to the inquiry. And
Did you all start the inquiry?
we had started. We
The-
were called after the documents were sent. My Lord, the direction is upon the registry to send the documents to my Lord Justice Dey.
It was sent on the 11th. It mentions
Yes,
Justice
my Lord,
Dey's
we have a
report is
date of 10th of August in our
Right.
report.
In the meantime, the matter was endorsed to Deborshi Dotto, IPS Special Superintendent of
Right.
Police by the DIG to conduct. From the status report submitted by such and such, it appears that the IO has practically completed the investigation without waiting for the supervision of the undersigned as directed. It is evident from the status report that 19 witnesses, including such and such, have been examined, has been handed over to me. I find that the entire investigation has been conducted by the Special Superintendent of Police, and further investigation would be a foregone conclusion. There is a report on record, I see. Let us go through it, what is there, and then we can come back.
I am not, my lord, if it is a report of my lord Justice Day, I am not having a copy of it.
Yes.
I am only having a status report of CID signed by the SSP, who was deputed.
Is it dated 28th of August 2023?
No, my lord, mine is dated as on date. 14 September, 19 September from Pustish.
It was 28th because it was forwarded to Justice Day on that date. But then what they have done, they have not done it under the supervision of the judge.
But after 10, my lord, we were called only on one day. My lord, the CCTV attack, the documents and the CCTV footage was asked for. We have already given it to my lord, but thereafter we have not been called to attend.
No, but then the report of Justice Day mentions that everything is over. The entire investigation has been conducted.
My lord, it has not been sent to QDEB as per the direction of my lord, and the CCTV has been sent to FSL. That report is still pending, and in the going by the, my lord, what we have seen in the other matter, my lord had been pleased to take statements individually out of his own accord from the relevant person, my lord. That can also be done, my lord. There is no resistance from our part.
Let us see what is there in the report.
This direction was given on 20th July. They have filed that report on 10th August, if I'm not mistaken.
No, my lord, the direct kindly.
It was forwarded
No,
to
yes.
Justice Day on
The
10th of
direction was
August.
upon the registry to forward, not on us to forward. So that was forwarded according to us on 10th of August. So what exception might have been taken by my lord is that why we proceeded in the meantime.
Right. That's my point.
A report filed by Justice Devi Prasad De, within bracket retired, is taken on record. Stop. Let the matter appear in the list on 21st September 2023 for passing necessary orders.
Take it up any day after 22nd.
After
Because
22nd,
presence of Mr. Bhattacharya is required.
presence of
Mr. Bhattacharya, he was appearing late.
26th of September. 26 চেম্বারে পাঠাবেন। এই সুব্রত রিপোর্টটা দেখি। Is it for extension of interim order?
Extension of interim order, my lord. Last occasion on 20th July
Where is Mr.
2023.
My dispose of the matter in a specific period, let the notice be kept in arrear. Subject to your lordship's approval.
Well, what notice is there? Demolition notice?
Demolition notice, their allegation is they have not been heard.
All right.
So we will do the hearing. And I think
That
that
one
will be-
notice was issued by the municipal authority, and by that notice, the petitioner was directed to appear before the hearing. Accordingly, the petitioner was appeared. On that day, my lord, the hearing was not done by the municipal authority and informed the petitioner that he will be informed about the next date of hearing. But my lord, nothing has been done. Suddenly, my lord, the petitioner came to know from the police authority, my lord, that the demolition proceeding will be conducted, my lord, with the help of.
Demolition order, please show.
My lord, kindly come to page 104, my lord, annexure P6. My lord, this notice was issued to the additional deputy commissioner of police, and by the said notice, the police was directed to give assistance to the municipal authority, my lord, at the time of demolition proceeding.
No,
But then you do not have a formal demolition order?
No, my lord, nothing has been received by the petitioner. Nothing has been served upon the petitioner, my lord.
Another allegation is earlier that HMC has gone for a demolition. When they showed that, the demolition team came back. Because I told at that
I have stated that, my lord.
Please come.
Anyway, I will give the hearing, madam.
Specific grievance of the petitioner is that the order of demolition was passed without affording any opportunity of hearing to the petitioner. Stuff. Next. The matter was heard by this court on 20th July 2023. Stuff. Next. As on date, there is nothing on record to suggest that the order of demolition was passed upon giving opportunity of hearing to the petitioner. Stuff. Next. In view of the above, the Howrah Municipal Corporation is directed to afford reasonable opportunity of hearing to the petitioner and all other necessary parties and pass order in the matter dealing with the issue of unauthorized construction. Stuff. Next. The impugned order of demolition shall be kept in abeyance till fresh order is passed by the corporation. Stuff. The writ petition stands disposed of.
Gratefully,
Lord has dictated, the last order was passed on 27 or 22, it will be 27.
No, 28. 20. I can see. Achha, add one more line. As the as unauthorized construction has been detected by the corporation, the petitioner is restrained from carrying on any further construction or alienating /
Third party right
transferring
may not be clear.
or create any third party right in the subject structure.
Gratefully. Gratefully, Lord.
My lord had granted me leave, my lord, to file and move the application on behalf of the CBI, my lord. But the application is there, it's listed. It's CAN number 7 of 2023, my lord. My lord, I'll be seeking my lord's kind leave, my lord, to press the application, my lord. My lord, we all know, my lord, about the background of this case, my lord. How, my lord, owing to intervention of the honorable court,
1 minute. 1 minute. The state is there. I cannot see you. You are behind the screen. You were directed to take instructions with regard to the steps taken pursuant to the GD. Let me see.
What?
Your report mentions that the computers were checked and 60 number of unknown Excel files in one of the computers and the traces of downloading them were not seized by the team of the Enforcement Directorate. So they were not seized.
That computer, that hard disk was
Not seized. So it implies that they do not intend to take any note of those documents which were downloaded, isn't it?
not that. They intended,
Well, had they intended to use them, they would have certainly seized.
But we have, in course of this inquiry, we have seized them, and we have sent it here.
But as of now, there is nothing to suggest that those documents which were downloaded have been used by the authorities against you or for the purpose of investigation.
Again, ask means not about ask as the
Means
signatory of
the,
report,
yes.
nothing to do with them, but however, we have given them email to send a representative. They have said that there is no difficulty. We have difficulty in sending a representative, but whatever query you have, you can give it by mail. And I understand, another criminal revision is pending before a coordinate bench. But however, though I'm not an appearing counsel there for the state, but from my counterparts there, what I learned is that this issue was brought up in that criminal revision, and it was verbally it was discussed in court that there is no harm in sending the email. However, I can ask my counterparts to come and make this.
No, that is all right. But the fact
I
that
can assist my lord as far as that is concerned, my lord, because in that regard only we have today, with my lord's leave, I have filed an application. It has been numbered as computer application number 8 of 2023. Now, my lord, there we have specifically mentioned, my lord, that this particular issue has been put to rest by the order of the Honorable Coordinate Bench of this Honorable Court, where Mr. Abhishek Banerjee had filed a criminal revision with regard to something else. He took out an application, the interlocutory application saying that this has happened. There is an undertaking given by ED that first of all, we have not seized it. And we are not going to use it as evidence because we have said that those are not such files that we wanted to do anything on. It has nothing to do with
the investigation.
Yes, my lord.
So what is the use of continuing with the same thing and harassing all these officers by giving regular mails, come, give this, that, why?
Mails mean, we have sent 2 to 3 emails only. The first one was seeking an answer, which they have given, that answer, also again, please.
No, but then after the authorities have submitted before the court that they are not going to use those documents, if at all, for investigation purpose, what remains right now? Right now.
This complaint which is there before us, we are only taking it forward in terms of the complaint. So it is not between the investigating, the person investigating here.
Very well, I have followed it.
That of the
Yes, I've got it. Anything else you want to submit?
I am for the CBI, my lord.
Yes.
Our application, my lord, we have challenged, my lord, the action undertaken by the special court, my lord, completely, my lord, ignoring, my lord, the law of the land, the hierarchy of courts.
Isn't your application pending before the Supreme Court challenging the action of the...
Court has granted us liberty. We had filed a clarification application.
Yes.
I'll tell you, lordship, what happened.
That is what appears from your earlier report.
Yes. My lord, I have revealed everything in my application, my lord, what has happened, my lord. Now, my lord, kindly he comes to the Supreme Court order once, my lord. It all started from the Supreme Court order at page 76. If your ladyship kindly takes pain to come to page 76 once.
Yes.
My lord, may kindly take note of the fact, my lord, the SLP was arising out of, my lord, the judgment and order dated 18/5/2023. My lord, may kindly mark, my lord, 18/5/2023. I'll just place the order dated 4th of August 2023. The grievance which has been addressed before this court by Mr. Such and Such senior counsel appearing for the petitioner is that it was not the petitioner who had moved the High Court, but it was the Enforcement Directorate who had done so. Moreover, it has been submitted that the complaint of the petitioner in regard to the allegation of custodial torture would have to be looked into by the competent court. In this background, it has been submitted that the observations on merit by the High Court were unwarranted, as also direction to deposit costs of 25 lakhs. We have heard Mr. S.B. Raju, Additional Solicitor General. Now, thereafter the finding, the High Court has clarified that at that stage, it was not expressing any opinion on the legality or correctness of the complaint in regard to custodial torture. In the circumstances, the impugned order, my lord, may kindly mark, my lord, the impugned order of the High Court shall not preclude the petitioner from pursuing the complaint before the special court. The order for payment of cost of rupees 25 lakhs shall stand deleted. Now, thereafter, my lord, may kindly, my lord, I'll be referring to your lordship's order, my lord, which was in effect, my lord, affirmed, my lord, in this SLP, because only the cost portion was deleted. And this particular, the impugned order, that is the order dated 18th of May, 2023, that would not have been a bar, my lord, from pursuing it, my lord, before the special court. This was the observation. It was not spelled out, my lord. as to, my lord, whether it is to be the CBI court or the PMLA court, because the CBI and ED are both investigating, my lord, in this matter. Now, if my lord kindly takes your ladyship's order, my lord, which starts at page, of the order, 18 by page 46. Now, my lord kindly takes page 66 of the petition, internal page 21 of the order, dated, my lord, 18th of May 2023. Now, the second paragraph, all applications as indicated in the order of the Honorable Supreme Court has to be necessarily interpreted as applications on issues not decided by the court. The same cannot be read as application with issues already adjudicated and decided by the court. If the formal interpretation is to be accepted, then there will be no end to a dispute and there will be a possibility of the losing party approaching the court to re-argue and re-agitate the issue all over again. Finality of an issue can never be reached. The same is contrary to the principles of res judicata. Now, my lord, on the strength of these observations of your ladyship, my lord, which was not, my lord, even, my lord, interfered with by the Honorable Supreme Court, my lord, these applications, my lord, are taken out at the behest of the CBI and the ED, my lord, because these are all subsequent facts, my lord. And, my lord, the law is very clear, my lord. Popular Muthaiya has said, my lord, that the Honorable High Court, while exercising powers, my lord, the powers are plenary in nature, and it can do anything ex debito justice, my lord, to correct the course of justice, where, my lord, it is basically an abuse of process. And there was another case also, my lord, that Rajesh Prasad, yes, 2014 SCC, I'll be referring to all of them. Supreme Court cases, page 257, which spells out that the court monitoring the investigation has to act as a guardian to ensure that the officers who are conducting the investigation are not exposed to unnecessary harassment from the persons at the top of the ivory tower wielding power. So these are there. So thereafter, my lord, I'll urge your lordship to kindly take a paragraph, my lord, thereafter, my lord, the paragraph that I placed, my lord, the last but one paragraph. The conduct of the applicants in resisting investigation casts a cloud on the bona fide of the applicants in filing the present application. AB, being in the top rung of the ruling political party, ought not to shy away from the investigation process. On the contrary, the applicants, and particularly AB, is trying tooth and nail to oppose such investigation. The proper approach would be to put oneself to test and come out clean instead of avoiding or running away from the entire process. Now, thereafter, this is very relevant, my lord. The state machinery, especially the police, also appeared to back the accused. The hyperactivism of the Superintendent of Presidency Correctional Home is also worth noting. The lightning speed in which the Superintendent acted on receipt of the complaint of Kuntal Ghosh is clear proof of his faithfulness to the state. Now, Kuntal Ghosh is already in jail custody and will be dealt with appropriately in accordance with law. At this stage, it does not appear that any of the rights of the applicants have been infringed in any manner requiring interference by the court, either by the act of the respondents or the order passed by the court. Now, thereafter comes, my lord, the observation of the Supreme Court, my lord, in the order that I just pointed out. Learned counsel representing ED, while referring to the complaint lodged by Kuntal Ghosh, has specifically pointed out that the complaint in question is neither in proper form nor in accordance with the provision of the jail code. The superintendent of the correctional home was extra vigilant and forwarded the complaint to the officer in charge, Hastings Police Station, with utmost promptness. At this stage, the court is not expressing any opinion with regard to the legality or correctness of the state complaint. The same will be taken on note at a subsequent stage if occasion so arises. Now, my lord, I'll just pause here for a moment, my lord. Now, this particular order, my lord, of 18th of May was under challenge. Subsequently, my lord, these matters were taken up by your ladyship, my lord, on 14/6/2023, 14/7/2023, and various dates thereafter. When, my lord, upon pursuant to directions by the Honorable Court, my lord, the CBI had filed a report insofar as, my lord, these particular allegations were concerned, pursuant to, my lord, directions of the Honorable Court. But that report were taken into consideration. My lord's order has also been annexed, my lord, the order dated 14/7/2023, where it has been specifically recorded about filing of the report and what is the conclusion in the report. Now, my lord, thereafter, my lord, I'll also refer to two more paragraphs, my lord, and I'll go to the order impugned of the special court. My lord, The last but one paragraph at page 67. After the first sentence, the applicants have indeed been successful in interrupting the investigation to a great extent. It is high time that the investigation process be brought back to the right track and proceeded in the right earnest so that the same reaches its logical conclusion at the earliest. If the trend to delay the main investigation and intimidate the investigating officers is not dealt with appropriately at the very first stage, then the same will develop as a style, and very many investigations in future may be held up for same reasons. Such a move must be stopped with an iron hand and upon imposition of exemplary costs, so that the same has a deterring effect and similar offenders will be compelled to think multiple times before adopting such a stand. In view of the discussions made thereunder, the applications were dismissed and a cost to the tune of rupees 50 lakhs was imposed, which was interfered with by the Honorable Supreme Court, and nothing else. And with this with this observation that he will not be, by virtue of the impugned order, the petitioner will not be debarred from pursuing the complaint before the special court. Now, after passing of this order, may I mention, also, that the original complaint made by Kuntal Ghosh, that is, with the records of the Honorable Court, with your ladyship, because those were, asked to be produced and the originals are there. Now, what happened thereafter? If kindly take page 78, this is where from it all started. The CBI court number 1, which is a charge court, But suddenly, on 21st of August, an application was filed by this under trial prisoner. But no application has been served upon the CBI till date. The CBI appeared and apprised the learned special judge about the fact that there are subsequent developments. A report has been filed and taken note of by her ladyship in the court-monitored investigation, which was deliberately not recorded. I am using the word consciously, deliberately not recorded. Thereafter, what happened was, the special judge suddenly said that I will call this Kuntal Ghosh, the under trial, to my chamber. I do not know what prompted him to call an under trial to the chamber. It was not an in-camera proceedings. Nothing has been spelled out for calling, of the under trial prisoner in the chamber. And thereafter, your ladyship kindly takes note of what has happened. I'll place the order. Accused Niladri Ghosh, Kuntal Ghosh, and Taposh Mondol are produced before this court. Honorable Apex Court has been pleased to direct, in the circumstances, the impugned order of the High Court shall not preclude the petitioner from pursuing the complaint before the special court. Honorable Registrar has been pleased to direct this court to comply with the direction. And as such, I have asked the accused, complainant herein, to come forward, and accordingly he is now in front of me. The original complaint lodged by Mr. Ghosh is lying with the Honorable Court. Kindly mark this. I have asked the person, that is Mr. Kuntal Ghosh, whether he will submit before me in presence of the learned advocates and other persons, or in my chamber. And the complainant, due to some averments made in his application filed earlier, wants to submit at my chamber, and accordingly I am directing IO to produce the complainant at my chamber. Kindly mark this, my lord. The special judge, my lord, volunteers that, will you like to tell anything here or in my chamber? It was not, my lord, at the behest of the under trial, my lord. Now, thereafter, what happens inside the chamber? Letter, order number 36. Kuntal Ghosh is produced before me at my chamber. There are two complaints. My lord, the records, my lord, what was handed over to us, my lord, by virtue of orders passed by the Honorable Court, my lord. I'm grateful to Mr. Bandyopadhyay, he had circulated copies. But there is only one complaint which was made, my lord, to the special judge. I do not know what other complaint he's referring to. The special judge was only, my lord, addressed with a complaint dated 31st of March 2023. But here he speaks about two complaints, and in his chamber. One against Vijay Kumar, Assistant Director ED, and one Ramdin Dagar, Deputy Director, and one DIG of CBI. On asking Mr. Ghosh, he ultimately has told his name as Ashwin Senvi. I fail to understand, my lord. A complaint is not there in its original. The complaint is lying with the Honorable High Court at Calcutta. In the complaint, there is nothing mentioned. It was said, the allegation was, my lord, as wild as one DIG did this and did that. So the judge, it seems, my lord, in the learned judge in the court below, literally, my lord, persuaded the under trial, and after such persuasion, but the name was spelled out as Ashwin Shenvi, because, my lord, this word ultimately, my lord, gives such feeling, my lord. That there was a lot of persuasion that you tell me, but this is nothing but a roving inquiry, a fishing, this is nothing but, my lord, fishing out of evidence. I'll refer to the provisions of, my lord, the Code of Criminal Procedure also. He is not even authorized, my lord, to take cognizance. And, my lord, what the Honorable Supreme Court directed was, my lord, to pursue the complaint, not to adjudicate. Now, my lord, kindly appreciates, my lord, what has been done, my lord, despite a court-monitored investigation being ongoing, my lord. The first offense was happened as per the complainant was at his residence lying and situated at Ujjwala Luxury Complex opposite City Center and tower number such and such. And another happened at ED office at CGO Complex, and another happened at CBI office Nizam Palace. The complainant categorically stated that he has no allegation against the prosecution agencies, but he has grievances against the particular persons considered. My lord, Mr. Shenvi, the DIG, has been appointed, my lord, as the head of the SIT by virtue of orders passed by the Honorable Court, my lord. Upon appointment of Mr. Shenvi, my lord, he happens to be one of the most competent officers, my lord, of the CBI. He has come from Chandigarh, my lord, to head the SIT pursuant to court orders. And, my lord, he has even, my lord, appeared before the Honorable Supreme Court, my lord, in SLP, connected with this scam, my lord, to apprise the court about the progress of the investigation, my lord. And after, my lord, Mr. Shenvi taking over as the head, my lord, there has been much progress, my lord, which we have indicated by filing reports, my lord, time and again, my lord, about, my lord, my lord, the acceleration, my lord, insofar as the speed of investigation in this mammoth scam is concerned, my lord. Now, thereafter, my lord, again, later order number 37. It is true that there are two parts of the allegation. The accused complainant herein wants to leave my chamber, and accordingly, I have asked the IO to take Mr. Ghosh at my ejlash. And thereafter, order number 37. It is true that there are two parts of the allegations. One is against two officers of ED, and another against one officer of CBI. As Honorable Apex Court has been pleased to direct this court to adjudicate the matter, my lord, kindly marks this, my lord. It was not the Honorable Supreme Court which said, my lord, that he has to adjudicate it. The Supreme Court spoke about pursuing it in light of the impugned order, my lord, that is the 18th May order. I am inclined to take both the applications of the complainant accused herein for passing order. My lord, I do not know, my lord, the originals are with your ladyship's record, my lord. But I have made a photocopy of, my lord, what was handed over to me by Mr. Bandyopadhyay, my lord. By the court, pursuant to Mr. Bandyopadhyay, pursuant to court's orders. Like so. Oh, he has given it to the court, and thereafter the court had, yes, court had circulated copies. Yes. But I have made this compilation. If my lord kindly takes the complaint, my lord kindly takes page 9. I'm sorry, my lord, page 7. Now, this contains the certificate under section 65B of the Evidence Act of the officer in charge of Hastings Police Station. Thereafter, page 8 is, my lord, the email. Page 9, the Presidency Correctional Home forwarding, my lord, the prisoner's petition. And page 10 is, my lord, the complaint addressed to the inspector in charge of Hastings. And thereafter, if your ladyship kindly takes pain to come to page yes, page 15. Now, my lord, this is, my lord, the only complaint which was addressed to, my lord, the special court. There are no two complaints, my lord. The complaint is thereafter, my lord. It runs from page 16 to page 20. This was a continuation. Two parts were made, ED and CBI. So there was this one complaint only. In any event, my lord, coming back to the order, my lord, I'll run through the, my lord, contents of the complaint again. As the accused has filed, both the complaints before this court and the original complaints are lying before the honorable court. At the time of adjudicating such type of matter, the matter should be dealt with in such a manner so that fairness of the judiciary should be highlighted. So no copy served upon the CBI, submissions not recorded, but my lord, this is highlighting, my lord, the fairness of the judiciary. The accused has fairly submitted that he has no grievances against the prosecution agency in one hand, and on the other hand, it is the duty of the court to look into the matter in such a way so that neither of the party can claim of causing prejudice to him. Considering all, I am of the opinion that if one report be called for from the Joint Director CBI and Joint CP Crime Detective Department Lal Bazar under the supervision of any learned magistrate, then question of causing prejudice to, if two has been missed out, to any person cannot and does not arise at all. So, my Lord Justice AMRITA Sinha's order, the observations made therein, which were not, my Lord, interfered with by the Honorable Supreme Court on 18/5/2023, my Lord, the observations regarding the role of the state, the hyperactiveness of the role of the police, my Lord, these were all brushed aside. I think, my Lord, it is only the Supreme Court and, my Lord, the special judge, the subordinate court, my Lord. There is no existence of any high court. I'll show, my Lord, what he is doing. Both the concerned officers are strictly directed to hear the grievances of Mr. Kuntal Ghosh, his wife Joyshri Ghosh, and will record their statement and record statement of any other person as may deem fit and proper. They shall record the statement of Kuntal Ghosh first, and then they are at liberty to hear the submissions of the persons against whom Mr. Ghosh has placed his grievance, and then they are at liberty to collect any other evidence jointly as they may think fit and proper, and ultimately Mr. Ghosh and the officials against whom Mr. Ghosh has placed his grievances will be examined in the presence of learned magistrate at his chamber or at any place as directed by learned magistrate, and in this matter learned magistrate will be treated as a representative of this court. Who is he? He's not a constitutional court. He has very, very limited powers which are regulated by the CRPC and by the criminal rules and orders. He's acting in an extra constitutional manner. He cannot direct the course of any inquiry. He cannot direct any officer beyond the rank of an officer in charge, an inspector of police, my lord, to take part. And, my lord, the facts, my lord, regarding, my lord, the orders being passed by the Honorable Justice Abhijit Gangobadaya on 13/4/2023, which was the merits of which were not interfered with by the Supreme Court, my lord. Only, my lord, there was a request made to the Honorable Chief Justice of Calcutta High Court to reassign the matter to any other bench, my lord. That was completely ignored. My lord's orders, the subsequent orders passed by your ladyship, my lord, those were totally brushed aside. Learned Chief Judicial Magistrate Alipur, being the head of criminal administration, is directed to depute one magistrate in this regard, and the concerned officers are directed to inform the learned magistrate well in advance as regards the date of examination as required as per the observations made herein above. The concerned officers are also at liberty to inquire into the matter by any other mode as they may think fit and proper, and should submit a report in this regard before this court jointly and or separately by 21/9. Thereafter, my lord, kindly takes, my lord, the last 3-4 lines. The application filed by Kuntal Ghosh, inter alia praying for sending the matter before the concerned police station, is dispensed with till arrival of the report. So Justice Abhijit Gangopadhyay's order dated 13/4/2023, which insulates the officers of the special investigation team against registration of any FIR or taking cognizance without the leave of the court, that is also completely, my lord, ignored. Because, my lord, he seems to have assumed a very, very special jurisdiction which finds no place in the Constitution of India, my lord. He seems to function, my lord, even not only a court of record, my lord, but a super court of record, having all the powers, my lord, which are also vested in the Honorable Supreme Court of India under Article 142 of the Constitution of India, and also, my lord, to the Honorable Constitutional Court, my lord, to, my lord, do justice, my lord, ex debito justice. Now, thereafter, my lord, the next order, the order dated 1/9/2023, received the letter of learned Chief Judicial Magistrate and also learned Judicial Magistrate, 3rd Court, Alipur, and Joint CP Crime. The intention of the court is not to submit conflicting decision or report, and he is doing that. The intention of the court is to obtain one joint report from Joint Director of CBI and Joint Commissioner of Police, D.D. Lal Bazar. The overlapping attitude is not expected at all, expected. Joint cooperation is highly solicited. Both the officers will fix date jointly and to do following acts. So thereafter, my lord, I have, my lord, there must be some typographical error. Doesn't make much sense what has been, my lord, intended to be recorded. Now thereafter, my lord, the last two lines. It is to be mentioned that if there will be any non-cooperation, then the matter will be forwarded before the Honorable Apex Court to date. A special judge. I was amazed. I was amazed. I was embarrassed. A charge court doing these things. So we file an application thereafter that please keep it in abeyance. We have gone before the Honorable Supreme Court of India seeking a clarification because there are subsequent orders, etc., etc. So that order, my lord, will find in page 83. So record is placed before me on the basis of application filed by Superintendent of Police, CBI, SIT. Peruse the application, documents annexed, copy served. Thereafter, learned advocate of Kuntal Ghosh has brought my attention in paragraph number 3 of application, and in this regard, I am of the opinion that rather than it can be said that Honorable Court has been pleased to direct this court to send the letter submitted by Kuntal Ghosh in original and as per the direction of the Honorable Court in WPA 7907 of 2019, this court has placed the before the Honorable, this is Hebrew and Latin, but before the Honorable bench directly, and the receipt of ACO of courtroom number 17 is here. And as such, question of seizing the matter by the Honorable Court cannot and does not arise at all. But the fact remains that the original letters are lying with the Honorable Court, and the Xerox copies, including the receipt copy of the Honorable Court, is lying with the case record. And the same I have already been mentioned in my order dated 21/8/2023. So thereafter, my lord, our prayer was considered. He said that no, you either get an order from the Honorable Supreme Court, otherwise I cannot keep any order in abeyance. So thereafter, my lord, we moved the Honorable Supreme Court of India. The Honorable Supreme Court of India on 6th of September finally said that, see, there are various other orders. We will not go into the merits of a finally disposed of SLP. So we are not entertaining the miscellaneous application. But however, we are granting liberty to the CBI, to the applicants to pursue the remedies in accordance with law. So on this, in light of, my lord, this particular, my lord, observation, the liberty granted, my lord, I mentioned the matter before your lordship, pursuant to which, my lord, leave was given by your ladyship. Now, my lord, the first aspect is, my lord, a magistrate, in a subordinate judge, my lord, is regulated, his functioning is regulated, my lord, by the Code of Criminal Procedure.
First address as to whether this court has jurisdiction to look into these judicial orders passed by the learned
Yes,
court.
yes,
below.
my lord has. My lord has.
Because there is a separate jurisdiction,
No,
the criminal
my lord
division
has.
jurisdiction can be availed of.
Very well. I'll tell your lordship why I am before your lordship, my lord. Now, there's this judgment of Popular Muthaiya, which is again a very popular judgment. Para 30 of Popular Muthaiya says that the Honorable High Court, while exercising incidental powers or supplementary powers, hearing applications, it can always exercise inherent jurisdiction. And it can do anything, my lord, in exercise of powers, my lord, the constitutional courts, my lord, to correct any wrong ex debito justice, my lord. So I'll just be referring to, my lord, paragraph 30 of Popular Muthaiya. And I'll just place para 30. In respect of the incidental or supplemental power, I'm sorry. Yes, I'm very sorry. 2006-7 Supreme Court cases, page 296. Yes. In respect of the incidental or supplemental power, evidently the High Court can exercise its inherent jurisdiction, irrespective of the nature of proceedings. It is not trammeled by procedural restrictions in that power can be exercised suo motu in the interest of justice. If such a power is not considered, it may even lead to injustice to an accused. Such a power can be exercised concurrently with the appellate or revisional jurisdiction, and no formal application is required to be filed. It is, however, beyond any doubt that the power under section 482 of the Code of Criminal Procedure is not unlimited. It can inter alia be exercised where the court is silent, where the power of the court is not treated as exhaustive, or there is a specific provision in the code, or the statute does not fall within the purview of the code because it involves application of a special law. It acts ex debito justice. It can thus do real and substantial justice for which alone it exists. Now, my lord, I'll garnish this with another judgment which speaks about, my lord, the responsibilities of an honorable court, my lord, in a court monitored investigation, my lord, that is reported in 2014, volume 14, Supreme Court cases, page 257. My lord, we have power, my lord, the high courts are courts of records, my lord, under Article 215, my lord, as the Supreme Court is, my lord. So, 2014 SCC, page 257. But the paragraphs which will be relevant are para 7 and para 27. Here, my lord, it was in case of a court monitored investigation, there was hindrances were attempted to be created. So what he did was, my lord, they directly approached the Supreme Court, my lord, under Articles 129 and 142. And this is what the Supreme Court holds. We are in this case concerned with the question as to whether, para 7, my lord, there has been any attempt on part of the respondents to interfere with an investigation which is being monitored by this court. When a court monitors a criminal investigation, it is the responsibility and duty of the court to see that the investigation is being carried out in the right direction, and the officers who are entrusted with the task be not intimidated or pressurized by any person, however high he may be. Considerable responsibility and duty is cast on the court when it monitors a criminal investigation. People have trust and confidence when the court monitors a criminal investigation, and the court has to live up to that trust and confidence, and any interference from any quarter to scuttle that investigation has to be sternly dealt with. Exactly these words were spelled out by your ladyship also in those paragraphs of the order dated 18/5/2023, which are very much subsisting, my lord, and which have, I will say, my lord, which have been affirmed by the Honorable Supreme Court. Thereafter, my lord, para 27. We may indicate that the petitioner has inter alia invoked the jurisdiction and power conferred on this court under the above mentioned constitutional provisions, and hence the consent of the Attorney General is not necessary. The petitioner is only expected to bring to the notice of this court the problems he confronts with while carrying on a court monitored investigation, and it is the duty and obligation of the court to see, rather than the petitioner, that nobody puts any pressure or threat on an officer entrusted with the duty to investigate a court-monitored criminal investigation. Any interference by anybody to scuttle a court-monitored investigation would amount to interfering with the administration of justice. The courts, if they are to serve the cause of justice, must have the power to secure obedience to its orders, to prevent interference with the proceedings, and to protect the reputation of the legal system, its components, and its personnel who on its behest carry on a court-monitored investigation. The court is duty-bound to protect the dignity and authority of this court at any cost, or else the entire administration of justice will crumble and law and order will be a casualty. Well, this is one of the second principle, my lord, where I am highlighting, and I am, my lord, also relying on my lord's observations in the order dated 18th of May 2023, my lord, where my lord had exactly anticipated what was happening. And now, my lord, the anticipation has merged with actual reality. To see, my lord, today I am coming up with an application as to what is happening. My learned friend, my lord, my counterpart, Mr. Trivedi, he is coming up with another application, my lord, demonstrating, my lord, what is being done with, my lord, the officers investigating, my lord, insofar as the ED is concerned. So it is continuing, my lord. Now, my lord, I am more on, my lord, the question of absurdity, my lord. My lord, what is, my lord, the most surprising and striking feature is, my lord, there are two complaints, my lord. One was made to the police by this under trial prisoner Kuntal Ghosh. The other one was made, my lord, to the jurisdictional judge, to the special judge. The special judge's complaint was dated 31/3/2023. The police a day after 1/4/2023. Both are there, my lord, what I have handed over. Now, my lord, there has been an improvement, my lord will find. The 1st April complaint has been improved from what was written in the 31st March, my lord, complaint. Now, my lord, the alleged period of torture insofar as, my lord, the CBI is concerned, but that dates from 20th of February 2023 to 24th of February 2023. Between these periods, he was produced, my lord, before the magistrate on 23rd of February, 9th of March, 23rd of March. I have the orders, my lord. The compilation contains the orders, my lord. The orders will be of much relevance because not only was he produced, the medical examination was done, SSKM doctors were there. Am I there, computer? Order? Huh. And he also moved bail applications, but nothing was spelled out. Till, my lord, these complaints, my lord, were on the 31st of March. So, once the complaint was placed before this particular special judge only, who has now, my lord, for showing, my lord, that impartial judicial my lord, functionality, my lord, has called this under trial prisoner to his chamber, volunteered, my lord, to ultimately disclose the name of something, my lord, which was not there, my lord. A complaint which is, my lord, inherently vague, my lord, and absurd, was attempted to be, my lord, even improved, my lord, by, my lord, possibly persuading, my lord. This is persuasion only, because ultimately the name was disclosed as Ashwin Shenvi, my lord. Now, my lord, the orders, yes. No, my lord, kindly takes, my lord, the orders, my lord. It starts from page 1, 23rd February. This is after the alleged period of torture. 20th of February to 24th of February, he is being tortured. He's writing to the jurisdictional, to the CBI judge that my private parts were under attack, and one DIG was telling me that, tell me how much money you have received from Abhishek Banerjee. Again, a day after that, on 1st of April, April Fool's Day, he's writing to the police telling that my private parts were under attack, and the DIG was forcing me to tell me whether if you have whether Abhishek Banerjee has taken any money from you or not. So there is a clear distinction, my lord, to establish, my lord, the absurdity. Now, my lord, the order dated 8th of order number 8, my lord, dated 23rd of February 2023. So Kuntal Ghosh, Niladri Ghosh, Taposh Mondol, they were all produced from PC. IO had prayed for JC in respect of accused persons such and such. Learned advocate for the accused persons move for bail on the ground stated in their respective application, and in particular, learned advocate of Taposh Mondol also moved for bail on the ground of his serious ailment. On hearing of both sides and on perusal of case diary, I can say that Mark Twain, my lord, the great American philosopher and writer, has been pleased to describe the chain of evidence as take a word, split it up into letters. The letters may individually mean nothing. When they are combined, they will form a word with the meaning. I don't know what he said. Learned advocate for the accused person submitted that the basic ingredients of section 7 and 7A of PC has not been established. Thereafter, my lord, the order runs to record. Medical report. So, my lord, he moves, my lord, a bail application, my lord, on the 23rd of February. My lord, the next order, 9th of March. Again, my lord, they are this. Oh, my lord is looking at the compilation, my lord.
No, I'm looking at your application.
Oh, application, yes.
Where are you reading from?
My lord, the compilation that I handed over containing the, my lord, the complaints, my lord, that contains the 3 orders also, my lord. Where, my lord, which demonstrates that this Kuntal Ghosh, he was produced thrice before the magistrate. My lord, during this particular interaction, 20th to 24th, there was torture inflicted according to him, which he informed, my lord, finally on the 31st of March. So, my lord, between that period, my lord, he was produced, nothing was spelled out. He was, my lord, he has moved applications for bail. He has got, my lord, even, my lord, medically examined. Nothing was spelled out till, my lord, this came. So the second order, my lord, 9/3/2023. Again, my lord, Kuntal was produced. My lord, 1, 2, 3. The 4th paragraph, application filed on behalf of accused Kuntal Ghosh and Taposh Mondol taken up for hearing. So he moves an application. Thereafter, my lord, CD peruse. Thereafter, my lord, peruse the report of the superintendent of Presidency Correctional Home along with report of senior medical officer. It appears that the medical board had been formed by SSKM Hospital and diet chart of SSKM Hospital is being followed. So everything was done. Nothing was spelled out. Thereafter, again, my lord, On 23rd of March, again he was produced. So Kuntal Ghosh, along with two others are produced. He once again moves another application, my lord, the fourth paragraph. Now the application filed on behalf of Kuntal Ghosh and Niladri Ghosh is taken up for hearing. So he moves for bail. The learned advocate for the accused person submitted that these persons are neither any government employee nor any person who has benefited by way of receiving appointment letter. Thereafter, again, my lord, the last but one paragraph, peruse the report of the superintendent of Presidency Correctional Home along with report of senior medical officer. It appears that the medical board has been formed by SSKM Hospital and diet chart of SSKM Hospital is following. So these are the observations. And my lord, the initial reaction of this particular judge only when the complaint was received. My lord will find it at the it's appended to the petition, page 28. This is the order dated 6th of April 2023.
Tell me one thing.
My lord.
What could the learned judge would have done? Because there is the court's order of the Supreme Court.
My lord, the Supreme Court had granted liberty to pursue it before the special court without spelling out.
What is to be done and how it is to be
No,
done?
I'll tell you, Lordship, my lord, I'm coming to that. It was only with regard to, my lord, the order dated 18th of May.
Yes.
The learned special court was apprised about the subsequent developments. Orders were shown on behalf of the CBI. That was consciously not recorded. We prayed, we pleaded, my lord, for a copy of the petition filed by Kuntal Ghosh. That was not there. First and foremost, my lord, under the CRPC, my lord, in the absence of a complaint, my lord, there cannot be any adjudication. There cannot.
One complaint was there.
No, complaints are all with the records of the Honorable High Court. He was not having any complaint. He is recording that. Despite that, he is proceeding in hot haste.
Original is not there, but the photocopy must have been there.
Without calling for the original, my lord, there cannot be, my lord, the courts which are confined within the four corners of the CRPC, my lord, which function, my lord, in accordance with the CRPC. They cannot go beyond that, my lord. They do not have, my lord, the plenary powers, my lord, which are, my lord, available, my lord, to the Honorable High Court and the Supreme Court, my lord.
So in the absence of the original complaint,
my lord, kindly takes the CRPC once, my lord, or kindly takes section 190, subsection 1, my lord. That speaks about complaint, my lord, adjudication on complaint. 190, subsection 1, subsection A. And that is what the Honorable Supreme Court also says. The role. Mind has to be applied. And that has to be done, my lord, specifically by a magistrate, not him. No.
So your submission is that in the absence of the original complaint,
My submission is, my lord.
it could not have been.
No, my submission, I will be referring to another judgment, my lord. So 190, cognizance of offences by magistrates. Subject to the provisions of this subchapter, any magistrate of the first class and any magistrate of the second class specifically empowered in this behalf under subsection 2 may take cognizance of any offence. Then A is upon receiving a complaint of facts which constitute such offence. So this is exactly what was there, but the complaint was not there. He should have ideally waited for further orders. He should have recorded that there are further orders passed by the Honorable High Court. There are subsequent development because the Honorable Supreme Court had made it subject only to the impugned order, my lord. The impugned order will not preclude because the High Court at that stage has not expressed any opinion. But thereafter on 16th of June and 14th of June and 14th of July, the reports were submitted, but the interim report was initially submitted. The final report was submitted. And it was contained, it was pleaded, but it was stated there in my lord that this is inherently absurd, but the opinion of the medical board, of the doctor seeing him, everything was collected. Everything is before your ladyship. He brushed aside everything. And he goes on, my lord, to adjudicate. He should have adjudicated, my lord. First of all, my lord, a criminal court under the CRPC cannot review its own decision. His first observation upon receipt of the complaint was, my lord, on 6th of April 2023, peruse the application of Kuntal Ghosh, which he has placed through Correctional Home Authority. As regards his allegations against ED is concerned, I have nothing to say. And as regards allegations against CBI is concerned, I am at a loss as to why he has not ventilated his grievances at the very first instance. So he himself is surprised. Thereafter, there is completely a volte-face, my lord. and he assumes unto himself the role of, my lord, the an extra constitutional, my lord, forum, I will say, my lord. That no, I have been given all the powers by the Honorable Supreme Court. Seems, my lord, I don't know, my lord. 226 also will be possibly adjudicated by him now. He will be issuing, my lord, writs of mandamus and habeas corpus also. So, my lord, this is one aspect, my lord. Now, what is to be looked into? But the Honorable Supreme Court says that whenever, my lord, in case of a complaint under section 191, subsection A, the mental process cannot remain conspicuously silent. Mind has to be exercised. The Supreme Court says that this is basically invasion on the privacy of someone, on the reputation of someone, unnecessarily harassing someone to go through the rigors of this procedure. But the Joint Commissioner, my lord, has made an observation about the role of the police. Thereafter, it is being referred to the police. From Caesar to Caesar's wife. When my lord is adjudicating, the court monitoring the investigation. My lord, as on date, since my lord is monitoring the investigation, my lord is the absolute authority before whom everything has to be indicated. My lord, popular muthaya, as I relied on, my lord. Now, my lord, so far as, my lord, 191A is concerned, first of all, my lord, he is not a magistrate. He is in the rank of an additional sessions judge, which again is a charge court, my lord. There are orders of transfer which has been issued. This particular court, my lord, there has been some other learned judicial officer, my lord, regarding whom, my lord, there has been a notification. There has been, my lord, the order has been passed, but it is not yet notified. And this is continuing unabashed, my lord. So, 2015, volume 12 Supreme Court cases, page 420. Now, the relevant paragraphs will be paragraphs 21 and 22. Well, last but one page, my lord, of the judgment. Para 21. Under section 191B CRPC, the magistrate has the advantage of a police report. And under 191C of the CRPC, he has the information or knowledge of commission of an offense. But under 191A, which is the case herein, though there was no complaint is with your ladyship, he has only a complaint before him. The court hence specifies that a complaint of facts which constitute such offense. Therefore, if the complaint on the face of it does not disclose the commission of any offense, the magistrate shall not take cognizance of cognizance under section 191A of the CRPC. Here, my lord, the discretion has been completely substituted. Inquiry has been directed whether to open the right window first or the left window first, whether to, my lord, whether to, my lord, comb my hair, my lord, with my left hand or right hand. That is also been, my lord, directed, my lord, by, my lord, a learned judge in the court below who is not competent to do that, my lord. He cannot travel beyond the parameters, my lord, of the Code of Criminal Procedure. He is not having constitutional powers. He cannot pass orders at his own whims and caprice, my lord. And that too, my lord, the practice and precedent is, my lord, when there is a court which is basically a charge court, my lord, only, my lord, formal orders fixing next dates are passed. That is the system, my lord, which is prevalent, my lord. Here we find, my lord, I don't know, I will term it as extreme exuberance, my lord, to excel as, my lord, an adjudicator. And there was no power of adjudication, my lord. I reiterate, my lord, for the sake of prolixity also, my lord, I am reiterating the fact, my lord. No adjudicatory power, my lord, was conferred unto the particular, my lord, judge in the court below, my lord, but to adjudicate, my lord. It was just to raise the issue or take the point, my lord. That was what the Honorable Supreme Court, my lord, observed. And that was also confined, my lord, within the four corners of the order dated 18/5/2023 passed by your ladyship, which was not interfered with, my lord, insofar as the merits and the findings in the order is concerned, my lord. And my lord has thereafter, my lord, taken on record, taken note of the fact, my lord, of the reports which have been filed along with supporting evidence, my lord, which were deliberately not recorded. My specific case is, my lord, the learned judge in the court below has acted unwarranted, occasioning failure of justice, my lord. He has acted in a manner which is not warranted by law by not taking on record our submission, indicating that there has been subsequent orders passed, and deliberately ignoring the fact, my lord, as regards the findings of the Honorable Court monitoring the investigation, my lord, regarding the role of the police. And also, my lord, the order dated 13th of April 2023, which insulates the my lord, members of the SIT who have undertaken the investigation. And also, my lord, I will say, my lord, this requires a formal admonition, my lord. He has, my lord, deliberately, my lord, he has deliberately, my lord, done something, my lord, which tends to impact, my lord, adversely, my lord, the dignity and majesty of justice, my lord, of a court of record, which we are, my lord, under Article 215. He has completely disowned and disobeyed the existence of the Honorable High Court at Calcutta. He has no authority to send anything directly to the Honorable Apex Court.
Very well. Now,
And my lord, two more judgments, my lord. First is this, my lord, paragraph 21. Then, my lord, paragraph 22, my lord, the last few lines, my lord, that it has to be, my lord, this will be an abuse of process. And once, my lord, dignity will be unnecessarily affected, my lord. So, these observations, and thereafter, my lord, I'll be referring to Bhajan Lal's case, my lord. Bhajan Lal, does it? This is a case, my lord, with 1992 supplementary 1 Supreme Court cases, page 335. The exceptions have been laid down in Bhajan Lal's case, para 102. Para 102 will be at page 378, my lord, of the judgment. But I'll just place the paragraph because this paragraph, my lord's query will also be answered, my lord. Whether, my lord, in exercise of constitutional jurisdiction, my lord, it can be done or not. In the backdrop of interpretation of the various relevant provisions of code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of extraordinary power under Article 226, my lord kindly marks it, which my lord is exercising while monitoring this investigation, or the inherent powers under section 482 of the court, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of process of court or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formula and to give an exhaustive list of myriad kinds of cases where such power should be exercised. My lord, straight away, my lord, comes to, my lord, the 5th and the 7th exception. The next page. Parameter 5, where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. And thereafter, para 7, where a criminal proceeding is manifestly attended with mala fide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. So, my lord, the observations of the Supreme Court, the findings returned at by your ladyship, and also, my lord, the findings returned at by His Lordship, the Honorable Justice Gangobadhyay, my lord, in the order dated 13/4/2023, my lord, clearly can be clearly linked, my lord, with these two, my lord, parameters. And, my lord, I'll also link another, my lord, insofar as the factual aspect is concerned, my lord, as regards the delay, the inordinate delay, my lord, and an afterthought of Kuntal Ghosh, my lord, to do this, to derail the investigation. Our investigation as on date, my lord, is suffering for the past 3 weeks, my lord. We are all running after this, my lord. We are going to the Supreme Court once. We are coming before your ladyship. We are making applications before, my lord, the special judge to keep things in abeyance, my lord. My lord, kindly appreciate, my lord, the last judgment, my lord, that I will be citing. But this is reported in 2004, volume 8, Supreme Court cases, page 40. Here it was, my lord, more or less similar, my lord, factually. Paragraph 20. My paragraph 20 is last but 2 pages. When the background facts of the case are considered, the question regarding applicability of section 197 of the code takes a temporary backseat. The factual scenario as indicated above goes to show that on 28th of February 1991, the respondent was produced before the magistrate. He was specifically asked as to whether there was any ill treatment. Learned SDJM specifically records that no complaint of any ill treatment was made. This itself strikes at the credibility of the complaint. Additionally, the doctor who has examined him stated that for the first time on 2/3/1991, he treated the complainant. Though there are several other aspects highlighted in the version indicated in the complaint and the materials on record are there, we do not think it necessary to go into them because of the inherent improbabilities of the complainant's case and the patent malafides involved. It is no doubt true that at the threshold interference by exercise of jurisdiction under section 482 of the code has to be in very rare cases. And this case appears to be of that nature. It fits in with category 7 of the broad categories indicated in state of Haryana versus Bhajanlal, which I just relied upon. It is to be noted that though plea regarding non-complaint before the magistrate was specifically stated to justify interference, the High Court has not dealt with this aspect at all, thereby adding to the vulnerability thereof. The continuance of the proceeding by way of prosecution in this case would amount to abuse of process of law. So, my lord, citing, my lord, these authorities, my lord, and the fact situation, as also, my lord, the findings returned at by your ladyship, my lord, which were not interfered with by the Honorable Supreme Court of India, my lord. I am submitting, my lord, before your ladyship in a court-monitored investigation. I am seeking, my lord, as of now, my lord, for quashing of this particular order, my lord, these orders, my lord, which are under challenge, my lord. And, my lord, the report, but there is another point, my lord, under the jail code, my lord. We have spelled that out, my lord, in our petition, my lord, that in so far as this prisoner's petition is concerned, my lord, this also is not in form with the jail code. My lord, we'll find mention thereof, my lord. Compare the jail code. Kindly takes page 19, para 22 of the petition, my lord. Page 19, para 22. Yes, the 22. Applicants most respectfully submits that the purported complaints filed by the applicant Kuntal Ghosh dated 31/3 and 1/4 before the learned special court are honest in the eye of law, as the same is not in proper form and manner as provided under the West Bengal Jail Code, that the purported complaints made by the accused Kuntal Ghosh were made in prisoner's petition permitted under Rule 615 of the Jail Code. Rule 615 as provided under the Jail Code is for the convict's petition to the district magistrate or his erstwhile employer or official superior. If the form number has been indicated, we have annexed the relevant provision. It is submitted that said Rule 615 of Jail Code is only meant for convicts to make their prisoner's petition. The said Kuntal Ghosh has not been convicted so far in either in the predicate offense or of the CBI or the money laundering offense under PMLA. That Kuntal Ghosh is an under trial having U2P number such and such. An under trial prisoner is regularly produced before the concerned courts for extension of judicial custody period. I had indicated, the orders, of production. And it is a matter of record before the learned special judge CBI court at Alipur that accused Kuntal Ghosh was produced before the learned special court on 23/2/2023, 9/3/2023 and 23/3/2023 prior to his filing of such false and frivolous complaints against the officer of the applicant herein. The accused has never even made a whisper of any complaint before the learned special judge CBI court or on any dates, let alone making the false and unsubstantiated complaints of the custodial torture. Thereafter, apart from that, in the next paragraph, the superintendent of the correctional home has to hold weekly parade of prisoners as per Rule 646, Thereafter, Rule 1084 of the Jail Code, speaks about the complaint parades, and 647 of the Jail Code, at least once in a day, visit all the prisoners and give them the opportunity of making the representations. This, I will say, has already, this has already, the hostility and the nexus, with the under trial prisoner of the state administration has already been reflected in your ladyship's order, of 18th of May, which has not been, expunged or interfered with, So, I will be praying, for quashing of these orders, of the special court, and I'll be pressing on, the prayer, that the report is before your ladyship, kindly, adjudicate, on the basis of the report which is before your ladyship.
Report you filed on the last occasion?
Yes, on 14/7, 14/6 we filed the interim report, and 14/7, we filed the final report. Both are with your ladyship. The difficulty is, the learned judge, in the court below, he has made the case returnable again on 21st of September, kindly quash it, or kindly stay the order, if feels that affidavits are required,
You mentioned something in the morning.
But I mentioned first, my lord, as far as this application is concerned,
Yes.
though my learned counterpart has, my lord, I'll not make submissions, my lord, but what is happening, my lord, that in that particular complaint which was made, of which my lord is in season of, which was argued by us from ED, my lord, 2 of our officers have also been named. Now, special court has not given notice to CBI also, giving notice to us because we are in PMLA court. No complaint is before PMLA court. So we are not also privy to what is happening there, though our people have been unnecessarily arraigned in that matter. Now, my lord, before that, my lord, I have just made, because my lord, I don't want to take much time of my lord. But my lord, what had happened, my lord? Why my lord has jurisdiction? Just 5 minutes of my lord. My lord, just certain pointers, just a recapitulation as to why happened, because this all was before my lord. And therefore, my lord wanted us to file reports. And reports have been filed before my lord. When reports are filed before my lord, and my lord is in season of the matter, my lord, this particular orders are unwarranted. Now, my lord will kindly see. And on what aspect, my lord? My lord, on 21st of January 2023, search and seizure was made at Kuntal Ghosh's residence. Then, my lord, on 21st, Kuntal Ghosh was arrested. Subsequently, there too, my lord, on 3/2/2023, learned special judge, special court KG, it was said, complaint, he was asked about his health, nothing was. Then, my lord, what happened was, when second bail application was moved, nothing was complained by him that something happened during the police custody. Then, my lord, when third bail application was moved and it was rejected, nothing was said. That was on 17/2/2023, my lord. Now, on 3/3/23, fourth bail application was moved, which was rejected. Another application for medical treatment in the super specialty hospital was moved by him, which was rejected. Nothing was complained of. So, my lord, all these days when he was in the police custody, thus no complaint was made. Then subsequently, my lord, we had argued before my lord that being bolstered by a particular speech, he comes up, and my lord, now these matters were before my lord, and my lord was in season of the matter. My lord had asked report, we have filed that report. Now, my lord, we'll kindly see on 14/6/2023, my lord, first report was filed by CBI on Kuntal Ghosh's complaint. And, my lord, on 14/7/2023, CBI filed final report before this honorable court, closing investigation. So, my lord, everything is before my lord. Now, my lord, so this particular order, my lord, and my lord, all applications can be filed before my lord. So, under these circumstances, my lord is in season of the matter, my lord. And what has happened, my lord, in this case? My lord, we kindly take up. First of all, my lord, again, at the cost of repetition, my lord, the special court has no extraordinary power, because, my lord, it has been established under the Prevention of Corruption Act, Section 3, my lord. And Section 5 gives the power to the special judge, which is only curtailed to the CRPC. Now, under CRPC, my lord, 482 is the only section which gives extraordinary power to this honorable court. So, my lord, when reports have been filed, my lord, the learned special court cannot order de novo investigation, that also by the authorities which have been kept in abeyance. My lord, now they are getting the state police into this particular investigation where it will be overlapping, and now it is retarding the investigation because we are being put to serious harassment. And we, ED, we are not also privy to any document from them. And now, my lord, before the PMLA court, my lord, this gentleman, Kuntal Ghosh, said that when the PMLA court asked him, my lord, I can give a compilation. It is all with my lord, because the last time when we argued, when my lord passed that order, which was challenged before the Honorable Supreme Court and not even touched, save and except, my lord, what has fallen. Now, my lord, there he said that nothing has happened. He was asked about his health. And about whether he said nothing. My lord will kindly recapitulate. Now, my lord, this is nothing but a ploy to harass us, my lord. And now, my lord, this judge in charge, my lord, exercising extraordinary jurisdiction from where he's getting power, my lord, we don't understand. And we are also not being allowed to, because, my lord, nothing has been sent. Our officers also named there, my lord. So, my lord, it is required, my lord, that my lord will kindly exercise power, my lord. Otherwise, my lord will kindly remember on the last occasion, My lord was wanting us to expedite. Now, how we will do this? Here at every nook and corner, every step, my lord, we are forced and retarded. The investigation is retarded by all these frivolous. My lord, we will fight them. We will run from pillar to post before this honorable court, or we will go on with the investigation. My lord. So, my lord, this particular issue has a checkered history where, my lord, he did not make any complaint regarding this. So, my lord, this needs to be, my lord, quashed, my lord. Well, we kindly see. My lord, I will give a compilation of dates, my lord, just a small list of dates, my lord. And my lord, at the best, when 2 reports have been filed before my lord with regard to this particular investigation, at the best, my lord, the learned special judge could have said that they can ventilate their grievances before my lord because my lord is in system of the matter. And because all applications, my lord, it has been directed by the Honorable Supreme Court that all applications are to be filed before my lord with regard to this. And my lord, we'll see, my lord, another application which I was moving before, that will come before my lord. For trivial issues, my lord, where we have said before the coordinate bench of this honorable court that we are not going to use them, we have not seized them, we have given an undertaking. Then also, my lord, they are harassing us when there is an order.
But if only that application may be taken up on some other day.
That application is not on record also.
My lord, my lord told me, my lord, we have filed it. I can give
Yes,
my
we
lord.
filed. We are not.
My lord will either take, my lord will kindly take it up tomorrow, my lord. Because again, we are also suffering there also, my lord. This is one place where we are suffering because anything which is happening in this particular proceeding, my lord, our officers have also been named. That also at a later instance. Every day, the person is coming up with new names. Whoever is made in charge of the investigation, his name comes up. Therefore, my lord, in this condition, my lord, we are working for benefit of the public at large, my lord.
Would the state like to submit anything?
If your lordship kindly permits me,
Yes, certainly.
that I will be very brief. That this is an investigation of a public scam. The division bench of this court held this is a public scam. It should be investigated, and the Constitutional Court, in fact, has initiated the investigation on our prayer. And all the issues which are related to this investigation should come before this court. Now, the alleged letter of Mr. Kuntal Ghosh, that was taken note of by this court. But apart from the fact that the contents are frivolous, anyone can read and start laughing, but I am not taking a lordship to that. And this court directed the CBI to investigate into the allegation. Now that investigation again is, my lord, initiated at the instance of a constitutional court. With deepest of respect, the court below shouldn't have at all ventured to interfere with that. If anybody has to say anything, ought to have come before a lordship. But the orders which have been placed by them, I am not repeating, in fact, really usurp the jurisdiction of the investigating agency by the court, while the complainant says we have no grievance against the agency. Then what is the intention? The intention is to delay the entire investigation, which has been repeatedly reprimanded by this court. Because the public scam is again sought to be, my lord, hidden under the carpet, adopting these tactics. Therefore, my lord has the inherent power to stay these orders and direct the learned court below. So far these reports are concerned, that will be considered by this court as it is considered, the court is already in session of this matter. And the change of the investigating authorities for that purpose, with deepest of respect, is uncalled for. I do not say anything more.
The PP is here. His application.
I just came to know, my lord, from certain that an ED has filed an application.
That application is not on record.
My lord, that application, my lord.
It's not on record as yet.
So, my lord,
We are not hearing that at least.
so let a copy be served upon my office. I will
Certainly.
definitely
Certainly it will be
address before
served.
your lordships, my lord, on that point. Because only one thing I'm pointing out before your lordship very kindly. Just a minute, Mr. Dhiraj Trivedi, and let me submit, sir. 1 minute. Let me submit. My lord, Mr. Bikash Ranjan Bhattacharya, learned senior advocate, and Mr. Dhiraj Trivedi was not there, my lord. But everybody had appeared before Justice Tirthankar Ghosh. And Justice Tirthankar Ghosh with regard to those 60. No, you were not there. Sheta noy. 16 downloaded files, my lord. Justice Ghosh made us a party there. And then, my lord, we had handed over the hard disks to the CFSL pursuant to the orders of Justice Ghosh. Justice Ghosh directed downloading of those files. Thereafter, Justice Ghosh again directed that those be submitted to us. That means the cybercrime cell. So, my lord, whatever before your lordship, since the application is not there, your lordship will fix a date. I'll come up before your lordship.
Let the application appear in the list. We
As
will
your lordship.
certainly fix up a date.
Yes, ma'am. My lord, what?
Not tomorrow. Come on Monday in that case.
Yes, my lord, come on Monday. I'll address you.
Tomorrow it's not possible.
Not harass us by writing letters and.
My lord, just before Justice Ghosh, the same point was agitated that they have written mails, and they have Justice Ghosh orally said that yes, if you have written mails, you reply or you don't reply. That is up to your wish. But that doesn't mean that they will raise this plea now again here, because once they have agitated the same point before Justice Ghosh.
Okay, well, the application, let the application appear.
Yes, sir is there. Same thing, my lord, same issues are before Justice Ghosh.
Monday, let it appear. We will see what is to be done. And when is the matter? When will the matter be taken up by Justice Ghosh?
My lord, Justice Ghosh has reserved it, saying that they have given final list of judgments and written arguments. So, matter is fixed on 19th. They could have moved
19th.
this. Yes, they could have moved this application before Justice Ghosh, because he is arising out of the same issues.
Lord, we will address, my lord, why we did not. My lord, will kindly see is the application.
No, we are not hearing that.
Well, there cannot be conflicting approaches before the different courts. In just court 34, they are saying something. In court here,
why I am approaching my lord.
No. Listen, let us come. Let us meet with the application on
I'm not forwarding my argument. I'm just retaliating to what is
on the 20th, because 19th it has been fixed by Justice.
Well, can it be on 21st, subject to your lordships? The 20th.
Then
my lord is fixing on 20th.
No, thing is that the ED officials are apprehending some type of action from
Well,
your
it's
end.
only at the stage of GD, general diary.
Whatever.
Whatever, my lord, keeps it. My lord, my learned friend will be prejudiced. He is there, my lord. See,
No, he will always be here.
No, my lord.
You may not be here, but then he will be.
have some personal difficulty.
20th.
So kindly keeps it on 23rd.
20? 21st.
21st. All right. October.
No.
21st is
September. September.
Next Thursday.
Okay.
Next Thursday.
Next Thursday.
And in the meantime, let these officers not be harassed.
Well, we have never harassed. We have writing mails is not a harassment. They can appear. They choose not to appear. They choose not to reply.
No, then that gives a wrong message also.
Well,
So that has to be kept in mind. You are writing mails.
Yes.
And then not replying or returning to the mail will
Well,
give a wrong indication.
they have already replied first time. They have said.
Then don't send any further
Well,
mail.
we have sent it, they will not reply.
No, why will you send? Tell me one thing. If you have sent a mail and there is a reply, what is the requirement?
They
of
replied,
serving?
said they never stated anything in their mails. That is why we said raise further questions.
Since it is before
All
the
right,
honorable judge,
will
it is better.
as your lordship,
Do
21st.
not send any further mails. Whatever the honorable judge will do, let us see.
Let us
Then
see.
Thereafter,
Yeah, exactly.
everybody can
Everybody.
pursue their own remedies.
Exactly, my lord.
Only with the approval of my submission kindly goes to the order of 13th April 2023, where the court directed it should be investigated by the CBI itself. That is at page 33 of the application. That's all.
With regard to the CBI's application, CBI's application, I don't have much to say apart from the point of view. It has already fallen from your lordship, because what they say is what I've gathered. But is that their submissions are on the periphery of abuse of the process of the court and the securing the ends of justice. So that remedy they have under 482. But what I'm trying to point out, and my lord will kindly not take me amiss because I was getting this submission, that whatever is transpiring before the learned magistrate is at the instance
Not the magistrate. He's not the magistrate.
before the
Special judge in charge.
at the instance of someone. Now, my lord, that person is not before your lordship, my lord. Who is defending this application, I do not know. He has moved, CBI has moved it, but who is defending it, I do not know. But my lord, that perhaps maybe the reason they are not before a 227 court, where they had to make the person a party. Because the parties are before your lordship in other applications.
No, in 227 proceedings also, there is no question of service, my lord. When my lord, the initial
At the first instance, I understand. But here, there is no one to defend the application.
So they filed applications for intervention, but that was rejected. That was rejected. Yes.
In the midst of all this, the real issue is going out of concern. Kindly take some my lord's order 29th August 2023.
Certain reports were directed to be filed.
The reports are not coming.
No, I have a report. I also have a report.
Yes, let it be placed. Let it.
Against all odds, we are still investigating.
Therefore,
We are progressing.
how do you know?
Kindly take the report, my lord. My lord, the
Yes.
report.
Let
will
it
be
be.
spelled out.
Yes, please.
Kindly, my lord, I'll get a copy fix করলো, Dhiraj copy fix করলো.
21st. Next
Thursday, my lord, the report we are filing, my lord. My lord, kindly, my lord, chase the order, my lord, for the order, my lord, of the special judge, my lord. Reports, my lord, may it be kept on record. My lord, kindly take consider the report, my lord, on that day.
Let me see.
The report by the board is not filed, which is more important.
Only one thing, my lord, that I will like to indicate. I had indicated it before the Honorable Justice Gangobadhyay also in the pending application, my lord. But we are filing the reports, my lord. I'll urge your ladyship, my lord, not to, my lord, even, my lord, disclose, my lord, what is there in the report. We have made that particular prayer also, my lord, in the last portion of the report. But now, my lord, they are getting to know the line of investigation undertaken by YAR. But as I was referring to, my lord, there now, my lord, twin towers, this is doing rounds, my lord, this has become viral. SSC and primary, my lord, they are two towers of corruption. Now, in SSC scam, my lord.
No, but the municipality is also rising its head.
Yes. Municipality, I'm thinking, my lord, how to term it, my lord. Trump Tower, no, Burj
Let us come to the issue. The report by the board is necessary.
No, my lord, what has happened is, my lord, the SSC scam, we had indicated, my lord, what we had retrieved, how we had recovered the OMRs. Now they got to know our line of investigation. Now, in respect of primary, what they have done is this S. Basurai and company, who was entrusted with the duty of preparing the OMRs, tabulating the marks and all. What they have done is retreat, my lord. They say that no, we do not follow the system of keeping any OMR sheet, soft copy of OMR sheet.
আগেকার দিনে যে রিপোর্টটা
We
ছিল
do not have any scanned images.
ED get that envelope.
No, why is the report by the board? That was
Was
the
the board also
specification.
supposed to file? What are have you taken any steps? Please come up. What you have done?
The board shall verify the credentials of the candidates, and if it appears that any of the candidates in the said list was appointed derogates of the provisions of law, the prompt necessary steps shall be taken. That was the steps to be taken.
What steps have you taken?
Yes, we have forward, we indicated that in the report.
What steps have you taken? You have annexed a big document. What are these? Now, to Kaushik Chaudhary, advocate, pertaining to the steps taken as to the board in respect. What are the steps taken? You have called them for hearing on the 19th.
By 4th of October, my lord, by 4th of October. আমাদের কপি দাও কি করছো final report 4th of October.
This is only showing that the names have been forwarded to you. The list containing the names on verification. Yes, ED has submitted pages containing 1894 selected candidates. On verification, we found that selection were made strictly as per the methodologies adhering to the 2016 recruitment rules. And the second list contains 250 candidates relating to such and such. The verified names out of it found authentic. Out of 250, you found 248 to be authentic. And this, you do not have? You do not have any existence in your record. How do they get appointment? If you do not have any existence, you have not recommended. Check up whether they are serving any school or not. And 63 candidates, their names have been verified. You have finished verification. Then why did you? Yes. And you found everything is all right. The documents and everything is all right. And what about the OMR sheets, the marks granted to them?
No, in all cases. No, they have to produce your OMR sheet to show.
Take this back because this will not be required.
Investigation of the SSC scam. Now they are doing the needful in so far as the OMRs are concerned.
Please come.
Now. So you need to believe that. দাঁড়াও সেটা তো চাইতে হবে ওরা রিপোর্ট দিক আগে থেকে গড়বড় করে লাভ কি কিন্তু বিল্লা দল তো বলছে ওরা সব এখন ম্যানেজ করে নিচ্ছে সেগুলো তো দেখতে হবে
Tell me one thing, Mr. Trivedi. PMLA scam you all are looking into. Are you aware of the assets of the persons in respect of whom you are investigating these cases? No, but then I have checked that nothing is there. So I would require some more information and documents from you. Can 7/20/23. And this is in connection with WPA 9979 of 2022. An application has been filed by the Central Bureau of Investigation, praying for appropriate orders. Apropos the order passed by the learned special judge. Learned judge hyphen, not special, a judge hyphen CBI court number 1 within bracket in charge at Alipur, 24 Parganas South. Stuff. Submission of the applicant is that the order passed by the learned judge is hampering the process of investigation which is being monitored by the High Court. Stop. Next. It appears from the order passed by the learned judge CBI court number 1 that which page is the last order passed?
Last order, my lord, find it. Page 81. Starts from page 80. Last order is at page 81. And 82 also.
He order passed by such and such on 21st August 2023 that the court directed a report to be filed by the joint director, CBI and joint CP within bracket crime detective department, Lal Bazar under the supervision of the learned magistrate. Stop. Next. Paragraph. The investigation of the recruitment scam is continuing under a special investigating team formulated by the Honorable High Court. Stop. Permitting any other officer to investigate the matter, now to investigate the complaint lodged by one of the accused may hamper the process of investigation by the special investigating team. Stop. Next. The paragraph, the special investigating team was constituted by the Honorable Court, keeping in mind the nature of complaint and the allegation that was required to be investigated. Stop. Next. Permitting fresh officers to investigate the complaint lodged by the accused, at this stage may prejudice the investigation itself. Stop. Paragraph. The very idea is to proceed with the investigation and not scuttle the same by appointing officers who are not part of the special investigating team. Stop. Next. The paragraph, for the time being, the direction passed by the learned judge CBI court number 1 within bracket in charge, dated 21st of August 2023, is directed to be kept in abeyance until further orders of this court.
Also, my lord, the order dated 1/9/2023. Two orders, my lord, of which one has paid for stay, my lord.
21st August 2023 and 1st of September 2023 shall be kept in abeyance for the time being. Yes, yes. The application And is it in connection with 9979? Another matter. A separate application has been filed by the Directorate of Enforcement, being CAN 8 of 2023. Let the same appear in the list on 21st September. Stop copy of the application be served upon all the respective parties.
No. How can it be?
1 minute.
Let me go to the Insta. I have to
1 minute. A report has been filed by, not a report, certain documents have been filed by the West Bengal Board of Primary Education. Whatever, these are also documents. Achha, do one thing, a bunch of letters addressed to the candidates by this Deputy Secretary, West Bengal Board of Primary Education, has been placed before this court. Stop. It appears therefrom that the candidates have been directed to appear before the Deputy Secretary on diverse dates with documents relating to the TET 2014 examination, TET 2020 examination, and the along with all documents, along with all other relevant documents. Stop. Next. Let further report be placed. Now let a comprehensive report by the West Bengal Board of Primary Education be placed before this court on the adjourned date. 21st. Very well. Let us see how much you proceed. And next, click on report filed by the CBI and the ED in court today are also retained with the records. Stop. Next. As the Enforcement Directorate is investigating the offences under the PMLA, let the following documents be placed before this court on the adjourned date. Number 1, the list of assets of leaps and bounds from the date of its inception. Second, the list of assets of the directors of leaps and bounds, the CEO and all the members of leaps and bounds. Third, the memorandum of association of leaps and bounds. Fourth, the articles of association of leaps and bounds. Fifth, the date of registration of leaps and bounds. Sixth, no, not sixth, a fresh paragraph. The report filed by the investigating agencies mentions about the involvement of several actors of the film industry. The names of the names and the list of assets of the members of the film industry which are under the scanner of the investigating agencies shall also be submitted before this court on the adjourned date. 21st. No, after this you will investigate. You will investigate. You want to say with the CBI? With the CBI. No, but then yes, I have returned it because you will conduct the investigation and then come up with a report. Where are the OMR sheets? How are you getting the marks? How have you given the marks? What records do you maintain? Digitized records. Whatever is there, you produce. We will see. You have called for the candidates to produce their records and everything.
The sheet must be produced.
That is one thing. That is for the purpose of the candidates.
But the plea of resorting to digital data, my lord, this is nothing but a sham, my lord.
1 minute. You
Mirror
have,
copy of OMR sheet.
you have directed the candidates to come up with their credentials. They may have the credentials, but appointment can be given only after they secure more marks than the other candidates. So the marks that you have allotted to the candidates, that will be required. That is a different aspect. That is also with regard to the credentials. No, apart from the credentials, whether they have secured more marks than the other candidates. No, that is for you. That is for you. That only 2 candidates. What about the others?
And my lord, as per the list of the ED has only given, my lord,
Yes. From the list you found only 2 were not there.
not there. Others have been, my lord,
All right. Everything is all right with them as per your records. So we will check what type of records are you maintaining. Yes.
But the order, my lord, passed in can 7, my lord, may it be a separate order, my lord.
Separate order means
Can 7.
can
Can 7.
be mentioned. Your order will be mentioned and then it will come.
Let also kindly ensure that the primary board produces the OMR sheet, if not the original, but the mirror copy, not the mirror copy of OMR sheet.
Mirror copy. And are you all maintaining mirror copies?
So this digitized is manipulation.
Digitized data is a sham, my lord. This is to shy
is
away
where
from
the
the actual
problem
state of
lies.
facts, my lord. They have
Where
destroyed
from?
everything, my lord.
Where from are you getting the digitized data?
And my lord, the greatest irony is, my lord, the digital data that they are harping on, that is editable, my lord.
Editable.
That is editable.
Whatever.
That's a different thing.
Grateful to you.
Yes. Tomorrow morning. Very well, tomorrow morning, give notice to your other side. Pradeep, number.
My lord, due to the extreme urgency, I am mentioning one matter in respect of item number 11, my lord. Kindly take the matter at 2 p.m., my lord. Otherwise, the community hall will be taken up by the Panchayat authority on the next day, my lord.
Who is your other side?
My lord, the Mr. Rudronil De and Mr. Shankar Dolopati both are present, my lord.
Come at 2 o'clock.
My lord.
My lord, before your lordship takes up the list, extremely urgent mentioning, otherwise I wouldn't have disturbed your lordship. My lord, on 12th of September, your lordship will remember, your lordship had posted the matter on 20th of September for the corporation to take instructions regarding that matter. My lord, they have already pasted.
Which corporation?
The municipal corporation.
Yes.
Pasted a notice for demolition of.
Who is your other side? Who is appearing?
Mr. Gopal Das was there. I'll give him notice, my lord. Kindly keeps it tomorrow, my lord, at the top, my lord. This is the notice they have pasted, despite your lordship clearly observing that nothing will, and in fact, your lordship will remember I was insisting that some protection may be given. My lord, they have done this, my lord. This is completely overreaching orders of court, my lord.
They are coming on Saturday.
Yes, my lord. Kindly see the notice, my lord.
Well, tomorrow. Give notice to Mr. Das.
Yes, my lord. Tomorrow, my lord, at the top, my lord, if it's possible. Deeply obliged, my lord.
Lordship, my matter was in urgent matter number 7. I just missed it today. Will it come up tomorrow or next week, ma'am?
Urgent motions remain in the list every day.
Ma'am, could you make it next week fixed time so that will be easy for me to follow, please?
Tomorrow you are not coming.
Oh, please, it will be difficult to every day to follow the list
Yes.
as in person.
Tomorrow are you
So,
coming or
No,
not?
make it next week, Thursday, so that will be final.
You want it on Thursday?
Yeah.
Not on Monday?
No.
On Thursday?
Right.
Very well. Item number 7 on Thursday.
Okay. Grateful, ma'am.
Passed over matter. Passed over matter. But after your lordship's observation, I have checked up. In the ED's list, this matter is not coming under the oil seals matter. And we have filed an application under RTI Act that this municipality is not subject to these ED's proceedings of the municipality. Just
All
now,
right.
the morning my lord is observed. We have checked up, we have all the documents.
Where is Mr. Siddiqui?
Mr. Siddiqui, we have my letter friend had a talk with him. He said he is now going out. Monday, Tuesday will not be able to come before my lord. And this is the position.
Then let his junior come at least. Somebody should be there.
Bothers for state. I don't see.
Nobody bothers for the state.
We had my learned friend has a talk with him.
Yes. He's going out where? Out of the country.
No.
Then he can join in online at least. Tell him to join online.
Informed him that my lord is holding
Yes.
the matter, please.
Is he there in court today? Because
No,
he was there, but he has left.
he is against me.
he has left court.
Court number 5.
Because that was submitted that he is on legs.
Yeah, he was on legs, but now he has left.
When will he come back?
No, he said not before Wednesday.
Not before Wednesday. So I'll keep it
all
on.
are out of employment, my lord, after having been selected.
Come on Thursday. Let us see what can be done.
Because we have concluded our submission. If you not
Thursday, I fixed up a lot of matters. In that case, Friday, 22nd.
May I suggest one thing subject to my lord present? My lord has concluded the hearing. Only these are the information my
What
lord
was
asked for.
there, I have practically forgotten.
So,
It was in April.
Is your lordship present to read it notes for your lordship consideration?
Now what happens? Notes come up more voluminous than the petition.
This was my Justice Bhagwati Banji's practice retirement. Everybody is jumping and everybody is saying I also said that I have a written argument. Written argument, come to my chamber. I went to his chamber in the recess. He has shown me one writ petition is this and the written submission in this.
Yes. So these type of written
I shall personally prepare it.
I have 2 points.
4 pages.
Not more than 4 pages.
4 pages? Not more than a page. Not more than 1 page.
That is not my lord will appreciate.
Yes, this is the reason. It's better to hear you and pass orders rather than go through all these, whatever is there in the notes and everything. Let Mr. Siddiqui come. We will see. Come on Friday.
Friday again, my lord, we will say he will be prayer, this, that.
Then at least tell him to join online so that we can hear what he has got to say.
I can do, my lord. He knows the matter is appearing. I cannot pull him physically.
Intimate his junior at least, some Mr. A. Adok. I can see his name.
The name is there, but
I don't know who is.
Cannot be in the panel now.
Adok is not there.
I'm not sure.
Then somebody must be there. Please intimate and come. I do not have any issues taking up the matter any day. He is available.
Should I inform the landed GP?
Very well, intimate. Give notice. No difficulty.
Friday.
Friday,
Let it be same
22nd.
position.
Friday week.
Same position. Friday week. Yes, Friday week.
Same position. It will remain in the list. Let us see. Which item was yours?
11.
11.
My lord, at first I want to file a supplementary affidavit, but praying for leave to file a supplement, which is very much relevant to the.
Have you
Yes,
served copy?
yes.
Let me see.
My lord, at first, my lord, kindly come to page 22 of my writ application. The Pradhan of the concerned.
11 number item.
My lord, at first, my lord, kindly come to page 22. This is the type copy of the impugned order, impugned notice. The concerned Pradhan of the Gram Panchayat issued a notice to the petitioner number 1 to hand over the key and possession of the community hall within 7 days. And my lord, now I am coming to the pertinent point. This community hall was established in the year 2021, my lord, in our plot of land by virtue of a deed of agreement, my lord. Chuktipatra was executed. But that is, my lord, page 16. My lord, kindly come. Page 16. These Chuktipatra were executed between the earlier Pradhan and the petitioner number 2. Now, my lord, kindly come to page 17. Shorto Kotha. The second paragraph, second paragraph onward. But may I be permitted to read it out? শর্ত কথা প্রথম পক্ষ নিম্ন তপশিল বর্ণিত কমিউনিটি সেন্টারটি বাৎসরিক 10,000 টাকায় দ্বিতীয় পক্ষকে বিলি করিলেন। পত্র ভাড়া বিলি চুক্তিপত্রটি ইংরেজি 13/12/2021 তারিখ হইতে বলবৎ ও কার্যকরী হইয়া আগামী 15 বৎসরের জন্য সম্পাদিত হইল। সেকেন্ড ক্লজ ইজ দ্বিতীয় পক্ষ উক্ত তফসিল বর্ণিত কমিউনিটি হল সেন্টারে ব্যবসা করার জন্য কাইন্ডলি মাই লর্ড ব্যবসা করার জন্য যে ইলেকট্রিক বিল আসিবে তাহা দ্বিতীয় পক্ষ আদায় দিতে বাধ্য থাকিবে এবং পরিচর্যা ও রক্ষণাবেক্ষণ দ্বিতীয় পক্ষ করিবেন। দ্বিতীয় পক্ষ তফসিল বর্ণিত ঘরটিতে ডেকোরেশনের ব্যবসা করিবেন। I was permitted to operate a business of decoration. তথায় কোনো অসামাজিক কাজকর্ম করিতে পারিবেন না, কোনো বেআইনি মালপত্র মজুত করিতে পারিবেন না, বা কোনো বিস্ফোরক জাতীয় পদার্থ রাখিতে পারিবেন না। ইহা প্রকাশ পাইলে উচ্ছেদের কারণ হইবে। দ্বিতীয় পক্ষ উক্ত ভাড়া বিলি ঘরটি অপর কোনো তৃতীয় ব্যক্তিকে উপভাড়ায় বিলি করিতে পারিবেন না, বা কোনরূপ পরিবর্তন করিতে পারিবেন না। সেকেন্ড মাইন, দ্বিতীয় পক্ষ ভাড়া বিলি ঘরে কোনরূপ মালিকানা পরিবর্তন করিতে পারিবেন না, শুধুমাত্র ভাড়াটিয়া হিসেবে গণ্য হইবেন।
So you are the tenant of that place?
Actually, yes, tenant, but this community hall has been established in our plot of land. By virtue of this, the community hall has been erected and constructed by the Panchayat authority, but same has been established in our plot. The land is in my possession. Now, my lord, on the next page.
Land is in your possession and you are the tenant?
Yes. Yes.
Land is in your possession.
Yes, it is my land. This is my land.
You are the landlord and the tenant, both are the
No.
same land.
I am the landlord.
You are the landlord and
Landlord.
the tenant.
Yes, by virtue of this agreement, the Panchayat authority was permitted to establish a community hall, and by virtue of this agreement, I was permitted to operate the same for the purpose of running a business of decoration, and same is being running. And my lord, kindly come to next page 18. এই চুক্তিপত্রে যে যে বিষয় স্পষ্ট লিখিত হইল না তৎ বিষয়ে পশ্চিমবঙ্গ বাড়ি ভাড়া বিধান অনুসারে পক্ষগণ নিয়ন্ত্রিত হইবেন। My lord, I am paying the rent, I am operating my business, and after the election, the new board of the concerned Gram Panchayat has been formed, and just coming thereafter, a notice has been issued. Madam, kindly come to page 22. That is the type copy, actual original.
Where is the document to show that you are the owner of the land?
Madam, kindly come to my lord, page 11 onward. Actually, this land belongs to my father. Till it is my father is no more, my lord. But kindly come to page 12. Page 12. Khotian number 45. Shamsul Kader. Shamsul Kader is my father, is our father. And he is no more. And by virtue of the inheritance, we are enjoying the property of the land. And my lord, now, my lord, kindly come to my supplementary affidavit. On 4th of November, this notice of handover of the key and possession of the community hall was issued, and immediately thereafter that writ petition was preferred. Now, my lord, kindly come to page 7, annexure P5 of my supplementary affidavit. The copy was immediately served upon the respondent number 6 on 7th of November. Just receiving the copy of the writ petition and several notice for handing over the possession of the community hall was immediately issued in favor of the petitioner number 1 as well as the petitioner number 2 with the attitude of vindictive. But it has been এতর দ্বারা আপনাকে জানানো যাইতেছে যে অত্র পঞ্চায়েতের অনুসন্ধান পূর্বক জানা যায় যে আপনি আউসগ্রাম থানার অধীনে রামহরিপুর মৌজার সাচ অ্যান্ড সাচ দাগের ওপর কমিউনিটি সেন্টারটি জনসাধারণের স্বার্থে ব্যবহার করিতেছেন না। এটা সম্পূর্ণ চুক্তি ও আইন বিরুদ্ধ। নাও মাই লর্ড, কাইন্ডলি কাম টু দ্য এগ্রিমেন্ট। As page 17, my lord, clause 3.
One minute. What is the next document? It is the same thing.
My lord,
4 and 5, same address to 2 different persons.
Yes.
It is the same thing.
Yes, 4 is initially.
Yeah, I followed it. Panchayat.
I am appearing for the.
My lord, I am raising the mentality of the writ petition. My lord, the further agreement, clause 1.
Further agreement?
Yes, my lord, the clause on page 17.
Yes.
The Pradhan, his tenure is 5 years. He cannot lease out any property of the Gram Panchayat.
Being official capacity earlier, yes.
Don't shout.
Let me
Made your submission.
He has only for 5 years or his tenure. In 21, that it is at least 1.5 years he has the tenure. He cannot enter into the lease agreement with more than 1.5 years. Secondly, there is no averment in the agreement that on the basis of the this resolution has been passed by the resolution of the Panchayat body by the majority members of
Tell me one thing, is the petitioner the owner of the land?
My lord, that part of
I am giving this.
Maybe the land is his, the
Yes,
Panchayat has made construction, the
No,
construct.
no.
No.
Originally, the land belongs to the father of the petitioner. And my lord, in 2020, my lord, by the dint of one Ongikar Patra, 4 decimal out of the 17 decimal of land had been gifted to the Panchayat.
All right.
And my lord, the Panchayat, after getting this property, and my lord, with the fund of the MLA fund, one community hall was constructed over that property. And my lord, after that, my lord, the then Pradhan, with his personal capacity, executed one deed of contract. And my lord, my humble submission is first point is when there is the contractual obligation not to be entertained by the writ court. Number 1. And number 2, my lord, the Pradhan, even today, the Pradhan have no authority to execute any agreement with the third party, because, my lord, when your lordship knows very well better than me, when any construction will be erected with the fund of the MLA or MP, and, my lord, the district magistrate is the authority to let out or to give lease or to whatever maybe can deal with this. And the Pradhan have no authority, number one, my lord. And the agreement, my lord, which annexed at page 16 of the writ petition, my lord, kindly have a look into page 16. Who execute? Pratham Pokko, Pradhan Bhalki Gram Panchayat. And, my lord, Ditya Pokko, the petitioner number 2. Although the writ petition was filed, both the brothers not claiming their ownership. And, my lord, they are challenging that without completing, when the agreement is not terminated till today, how the agreement to be, how the petitioners to be ousted from that property. And, my lord, the petitioners are holding that property illegally. When it was found, and, my lord, there is no resolution at all in the panchayat to let out the property to the petitioners.
Please come to page 18.
18.
See, it is signed by the Pradhan.
Yes.
Countersigned by the Nirman Shahayok, then by the Upapradhan.
Yes.
So you cannot say that the Pradhan did it in his personal capacity.
My lord, there is no
Had it been
resolution at all.
if the Pradhan has done something which is contrary to the prevailing rules and the laws, these persons, the fact that the Nirman Shahayok and the Upapradhan signed it,
Yes.
gives some credence to this document.
Yes, my lord. That's why subsequently, my lord, another resolution was adopted by the panchayat, my lord. I am handing over this, that this agreement was executed illegally. That's why it is terminated, my lord.
It's terminated?
Yes.
No.
That resolution I am handing over.
Wait. The submission of Mr. Mahato simply false. Why is the Nirman Shahayok, why has the Nirman Shahayok signed it? Then?
But there is no amendment by the majority members of the by the
It is, that is.
My lord, may I hand over?
Yes,
my lord?
please give.
My lord, I am sorry for mark. My lord.
It doesn't matter. What was the Nirman Shahayok doing? Nirman Shahayok is a government authority.
Yes.
Then?
My lord, the mark portion, my lord.
This is dated 3rd December 2021. And this is 7th October 2021. Please read out. Meeting Sadhan Sir, Sadhan Sabha, Siddhanta Mota, Vidhak, with the Nirman Committee.
Hand over the অঙ্গীকার পত্র also. It is yourself given. And my lord, I am handing over the অঙ্গীকার পত্র, my lord. No, then.
And my lord, kindly see the unregistered Ongikar Patro.
See 1 minute. This marked portion is dated. What is the date? (22nd of September 2022). Was the petitioner intimated about this document?
No. No, my lord.
Then how will the petitioner get to know that he was
Only, my lord, the
terminated his
petitioner had
contract?
been issued the notice and to ask him to hand over the possession of that community hall.
But then you should be letting the petitioner know as to why you are asking him to hand it over.
My lord, it should be, my lord. It should be.
First. Second is, it mentions about a date 7th October 2021. I see this agreement was executed on the 3rd of December 2021. And one more thing is, the petitioner was supposed to pay 10,000 rupees.
Yes, I have paid, my lord. I have paid. My lord, kindly come to page 19.
Is the petitioner paying the money?
My lord, yes, the Gram Panchayat did not receive rupees 1,80,000, which had been stated in the petition, my lord.
Where?
Not received. What about these receipts that has been annexed?
Milord, only 45,000 is deposited in the account of the panchayat, not 1,80,000.
Well, kindly see the
This is my
agreement.
instruction, Milord, on instruction I am.
Kindly see the agreement. There is no mention. There is no terms and clause regarding the rupees 1,80,000.
Why did you pay 1,80,000? For what reason?
No, my lord.
Did you pay?
No. I have paid 10,000 for the first term, and after completion of the year, it will be paid also. First installment has already been paid, 10,000.
First year, Bakshorik 10,000.
Yes.
So per year, you are supposed to pay 10,000.
10,000.
2021, you paid.
Yes, 21 to 22, I have paid. And 22 to 23 is
due.
It will be paid, my lord, in course of the December.
Right. But then what about 1,80,000?
But there is no reflection regarding the 1,80,000 in the agreement. How do I know, my lord? It was not communicated to me. Even Mr. Mahato is saying there is no regulation. The taking of regulation is the part and parcel of the Panchayat authority.
Why does 1,80,000 come into existence? Where from are you getting this figure?
Yes, Milord.
He is supposed to pay only 10,000 rupees. Even I was wondering, how could the panchayat lease out this portion with only 10,000 rupees annually?
Yes, Milord.
Because it has been erected in my plot of land, my lord.
Then you have gifted that plot of land.
No, my lord, it is unregistered. So, there is no value. Kindly consider it, my lord. Unregistered Ongikar Patro.
Let me see the agreement.
No revenue has been paid. Nothing has been, only 20 rupees stamp paper. It has been executed. I was asked to put a signature. Being the layman, how do I know? They have not taken, they did not take any regulation.
Notary. This is also notary.
Notary, but there is some value. It is a notary. It is also not notarized. Ongikar Patra is not notarized.
Milord, again, I am inviting your lordship's attention. Kindly adjudicate whether this contractual obligation to be adjudicated by the writ court or not. Milord, if your lordship allow me, then I can hand over 2 judgments of the Supreme Court, Milord.
There will be 200 judgments in your favor.
I know the lordship knows very well, Milord. And
I am aware of
it. Is completely contractual obligation in between the earlier Pradhan and the
earlier Pradhan. My lord, that is very opposite. Should be opposite.
After taking the charge of the new Pradhan, Milord, everything is found out. And Milord, on instruction, I am honestly
earlier Pradhan has taken his or her share and gone. And now the new one has come. Now he also wants his share. The moment share is given, everything will be formalized.
Yes. And just sitting on the chair of the Pradhan, he should just.
What was the Nirman Shayok doing? Why did he become a party to this agreement? No, but then he is a government employee.
He must have been the employee of the panchayat. Executive assistant and the secretary.
Kindly consider one thing, my lord. Initially, notice was issued in favor of the petitioner number 1.
Please come. The petitioner is aggrieved by the notice issued by the Pradhan Halki Gram Panchayat, Ayush Gram 2 Panchayat Samiti, dated 4th September 2023, and the subsequent notice dated 7th September 2023, directing the petitioners to hand over the possession of the community hall used by the petitioners. Stop. Next. The petitioners rely upon an agreement dated 3rd December 2021, entered upon by the, executed by the Pradhan of the Gram Panchayat and the
Nirman
petitioner number 2, whereby the said community hall was given to the petitioner number 2 on a yearly rent of rupees 10,000. Stop. There was a tenancy agreement in between the Pradhan of the Gram Panchayat and the petitioner number 2. Stop. Next. The agreement was signed by the Pradhan, comma, the petitioner number 2, and the witness was the Nirman Shayak, the Upapradhan, and there is one more, I cannot read the seal. Number one cannot be read. Of the Gram Panchayat. Stop. Next. The petitioner submits that.
Secretary in charge. Secondary. First one is the secretary in charge.
Original to
The learned advocate for the petitioner submits that the aforesaid notice was issued without affording any opportunity of hearing to the petitioner. Stop. As per the tenancy agreement, the community hall in question was given on rent to the petitioner number 2 for a period of 15 years. Stop. Next. Learned advocate representing the panchayat submits that the agreement in question was subsequently terminated. Stop. It has, however, been fairly submitted that the fact of termination of the agreement was not communicated to the petitioners. Paragraph. It has been submitted that the Pradhan could not have entered into an agreement of such nature with the private respondent. Stop. The land in question where the community hall was set up was gifted by the recorded owner in favor of the panchayat by way of an agreement of gift. Stop. Next.
Unregistered, my lord.
Learned advocate representing the state respondent submits that it was not proper for the Pradhan to enter into such type of an agreement. Stop. The respondents are ad idem with the submission that the writ petition is not maintainable. Stop. Contractual obligations of the parties flowing from a contract ought not to be adjudicated by the writ court. Stop. Next. I have heard the submissions made on behalf of all the parties and have perused the materials produced before this court. Stop. It appears that an agreement was entered into by and between the Pradhan of the Gram Panchayat and the petitioner number 2. Stop. The fact of entering into the agreement is not disputed by the parties. Stop. It has been submitted that that execution of such type of agreement is impermissible in law. Stop. Next. It appears that the land in question was not formally gifted. Stop. And not formally gifted to the panchayat. Stop. There is no registered document showing transfer of the said property in favor of the panchayat. Stop. As on date, the land in question is recorded in the name of the father of the petitioners since deceased. Paragraph. The panchayat has already taken has already adopted a resolution to cancel the concerned agreement. Stop. Next. As it appears that the fact of cancellation is yet to be made known to the petitioners, and the notice requiring the petitioners to hand over the possession of the said community hall was issued without affording any opportunity of hearing to the petitioners. Accordingly, the Pradhan of the Gram Panchayat is directed to give an opportunity of hearing to the petitioners to produce all relevant documents in support of the agreement in question. Stop. The Pradhan of the Gram Panchayat do one thing. যেখানে প্রধানকে বললাম opportunity of hearing দিতে, you make it the block development officer.
My lord, ঠিক আছে।
BDO
Outram
Outram 2 development block. ঠিক আছে? The impugned notices directing the petitioners to hand over the possession of the community hall shall be kept in abeyance till a decision is taken by the block development officer. Stop. Next. Opportunity of hearing shall be provided by the block development officer to the representative of the panchayat and the petitioners at the earliest, but positively within a period of 8 weeks from the date of communication of this order. The writ petition stands disposed.
But the affidavit of service be kept with the record.
Yes, service taken on record. A supplementary affidavit filed on behalf of the petitioners be taken on record.
Deeply obliged.
May I take back the copy of the resolution?
Take it.
এই আমাকে একটা দিও।
Grateful.
একটা জিনিস লিখে নিন তো। It is made clear that the court has not entered into the contractual obligations, if any, of the parties, and the BDO shall take an independent decision in the matter. After hearing the submissions and upon perusal of the documents placed before the said officer. Yes. All the applications.
There was a direction upon the school authorities and DI Mylar to file a report in the form of affidavit.
Has copy been served upon you? Where is the copy? Direction upon you to file a report. So where is the copy of your learned friend? Copy you will not serve. They did not serve you copy. Which copy? What was the order? The petitioner seeks transfer on medical grounds. You are this school. What is your submission?
I will file the exception.
Very well, but what is your submission? Did you serve copy upon the rest? Let me see.
Last occasion also DI did not appear.
No, last occasion the copy could not be served. The contempt rule could not be served.
The incumbent has been changed.
Who appeared in the writ? Did anybody appear?
Page 85 control states.
আসুন তো দেখি। Report filed by the alleged contemptor number 3 is taken on record. Stop copy of the same handed over to the learned advocate representing the petitioner in court today. Stop. The petitioner seeks to file an exception to the said report. Stop. Let the exception be prepared and served upon the learned advocate representing the petitioner by 28th of September, fortnight. 28. Stop. Next. None represents the District Inspector of Schools, Secondary Education, Paschim Mednipur, despite service. Stop. Learned advocate for the petitioner is directed to serve a notice upon Mr. Supriyo Chattopadhyay, learned advocate, who represented the state respondents before this court in the writ proceeding. Stop. Mr. Chattopadhyay is directed to take necessary instruction in the matter. Stop. Next. Let a copy of the report filed by the school authority in court today be also forwarded to Mr. Chattopadhyay. Stop. Let the matter appear in the list on 12th October 2023.
Then I will forward
The
the report.
District Inspector of Schools is directed to forward necessary instruction to the learned advocate.
But I will serve the report to Mr. Chattopadhyay, madam.
The
Copy
yes,
of the-
and the copy of the contempt and everything,
Yes.
so that he can at least apprise his clients. Twelfth of October. Huh? Yes, call the next matter.
My lord, I am the petitioner in person of item number 297. It is the next matter. As per your lordship's direction, order dated 18th May 2023, I have served notice again upon the respondents. I claim leave to file my affidavit of service.
Who is the
My lord, I beg to submit one thing. Each and every occasion, the service is a copy sent to the respondent number 6 returns to me with the posting of door locked.
who is the respondent number 6?
The private resident, Gautam Chaudhary.
No, if the private
No,
respondents.
My lord, I am telling you, he's a permanent resident of that residence, of that address. But I have talked to the postal peon. Why each and every occasion you have you have the envelopes returning to me with the note for door locked. He said that I had knocked the door, but they did not open. That is why, therefore, I beg to draw the kind attention of the Lordship regarding order
Don't show me so much of law. You show me what you want.
And this is an application order to Rule 6 CPC. The judgment on admission, your Lordship will kindly go through the recitals of the amendments of the writ petition from paragraph number 12 to 20. It has been elaborately discussed. Why I am entitled to get the judgment on admission that the process being marked as 3 and 4A should be declared as public street.
Should be declared as public
street.
Public street.
Yes. I have elaborately discussed the proposals laid down in Section 2, Clause 26 of Western Municipal Act, Section 2, Subsection 51 of Western Municipal Act, 120, Subsection 2 of Western Municipal Act, 1992. It is joining, these two strip of lands are joining the two public streets, namely Necessary Source Avenue and this by the Gully. The admission is there. Mother, I am telling you, Lordship, previously, my father had the writ petition India.
1 minute. Let us see who is appearing. Ritesh Kumar Ganguly. He is appearing on behalf of the respondent number 5. Are you aware?
Ritesh Kumar Ganguly. Oh, no, I am not.
You are not aware. Ended appearance on behalf of the respondent number 5. Are you aware who appears for Srirampur municipality?
Yes, Gautam Lahiri.
Yes.
Gautam Lahiri.
Did he enter appearance in this matter?
My lord, he was talking to me in the corridor that he has lost the writ petition.
He has lost the writ petition?
Yeah.
Tell him to come. Tell him to come.
My lord.
Are you aware of his phone number?
I know his residence. I can go to his residence.
Residence, I am not telling you to go. Are you aware where he sits here?
Yes, no, he sits in small college school.
Very well. You can give notice to him.
Yes, I already sent notice to him.
And one more thing, you also served the learned advocate Ritesh Kumar Ganguly.
I have served by speed post Chovirani Ghosh, the respondent number 5.
Yes.
I have served by speed post to Mrs. Chovirani Ghosh, the respondent number 5.
Learned advocate has filed wakalatnama. You serve upon the learned advocate.
The problem is this: I don't know who is the gentleman.
Yes.
I do not know who is the gentleman.
Yes. Please take down the phone number.
Ritesh
Kumar Ganguly. Care of Messrs. Mitter and Boral. 11 Old Post Office Street, first floor. The wakalat number is here. You can please take down the phone number and everything from here. So the respondent number 5 can be taken care of. And Gautam Chaudhary.
Gautam Lahiri.
No,
Gautam Chaudhary, respondent number 6.
Respondent number intimation served. and you give one notice to the learned advocate representing the state. Possibly the advocates whose appearance is marked over here, they may not be in the panel. I'm not very sure. Check up whether they are in the panel or not. You serve notice. In case they are not there, serve a notice upon the GP. Have you followed?
Yes, ma'am.
Next Thursday. Or you want one more week?
No.
Next Thursday.
I want it to be done. The unfortunate thing is this, my father being a
I will hear you. On the next day, you serve notice, ensure presence of the learned advocates. Mr. Lahiri is there, Mr. Ganguly is there, and anybody for the state. Right? Then we will hear it. Please come.
My lord, I want only one prayer, my lord. Inspector in the CM police station may kindly be directed to confirm service of the respondent number 6. Inspector in charge.
How will the IC serve upon the respondent number 6?
My confirm service. Because he is the respondent number 4. That is why I was showing you lordship. The process laid down in order for review 20.
None appears on behalf of the respondents. Stop. Next. It appears that the respondent number 6 cannot be served. Stop. The petitioner submits that the respondent number 6 is a permanent resident of the address mentioned in the cause title of the writ petition. Stop. According to the petitioner, the respondent number 6 is deliberately refusing service of the writ petition. Stop. Next. For proper adjudication of the issues raised before this court, the presence of the respondent number 6 may be required. Stop. Next. The officer in charge.
Inspector in charge.
The inspector in charge, which place?
Srirampur police station.
Srirampur police station is directed to serve notice, now to forward a copy of the writ petition.
Writ petition, yes, received. Can you see affidavit of service? Yes, it's the writ petition.
Who has received?
Potam Choudhury.
He has received.
Yes, affidavit of service is there, my lord. Further is this, he is receiving 10th of 2020 and all the subsequent notices mentioning.
Will serve notice. Will forward the notice, which will be handed over by the petitioner to the officer in charge.
Inspector in charge.
Inspector in charge. Srirampur police station. The petitioner is directed to serve notice upon Mr. Gautam Lahiri, learned advocate, who usually represents Srirampur municipality before this court, the learned advocate representing the state respondent, and Mr. Rajesh Kumar Ganguly, who has entered appearance on behalf of the respondent number 5.
What is it? Ritesh Kumar Ganguly.
Ritesh Kumar Ganguly. Dekhe nemen to namta. Ritesh Kumar Ganguly. I have put a flag mark. You can take down his phone number from here. Intimating that the matter will appear in the list on 28th of September.
28th of September.
2/8.
I petition in person. Petitioner in person. Oh, acha.
I'm for the petitioner. This is my
affidavit
of service.
I beg to appear before your lordship, my lord, on behalf of the alleged container number 2 and 3, your lordship.
On the last occasion, your lordship was pleased to direct me to serve a notice upon the newly added container as well as the private I have served and I have had the affidavit. Is a
Has the order been complied?
No, madam.
No.
So kindly come to the contempt petition.
No violation is there, your lordship. Respectfully
Kindly allow
submit,
me
my lord.
to, kindly allow me
Before
to
your
make my-
lordship's order was passed on 18 January 2021, my lord.
and your lordship was also
Completion of
pleased
the
to
my lord.
direct me to
I will hear you, Mrs. Maiti. Please wait.
My lord, your
lordship
lordship,
was
your
also
lordship.
pleased to direct me to hand over copy recent passport, recent photographs in the order it has been recorded. Now, your lordship, I will come to that, my lord. Your lordship first come to the my contempt application,
Allegation of unauthorized construction.
unauthorized construction.
All right.
First, your lordship, kindly come to the page 20 of my contempt application, in which is under challenge in the writ petition. I will not take
Page.
page 20 of my
20.
contempt application. The order which is under challenge in the writ petition. I will come 2-3 paragraphs, my lord, only.
Yes.
Now, your lordship, kindly come to the 1, 2, 3, third paragraph from the bottom. May I read, my lord? On the other hand, learned advocate Kushal Mishra appeared on behalf of the private respondent and submits that the owner, though through their promoter developer, have made construction G+3 residential building such and such as per sanction plan, by number such and such, dated 14th March 2019. Now, your lordship, kindly come to next paragraph. Moreover, learned advocate further submits that the further construction over the G+3 building was started after expiry of the 2 months after submission of the plan on 18th May 2020. You also can mark the date, 18th May 2020. This has been, they have. Now, you'll also kindly come to the next paragraph. On the basis of the facts and circumstances as narrated by the parties and their learned advocate, and keeping the mind in direction of the Honorable High Court in the above referred matter, an inquiry was made by the SAE Municipal Administration on 6th October 2021, came to the decision on the disputed matter of violation of the sanction plan. In question, nothing is found regarding deviation of the plan as vehemently argued by the author. Now, you will also kindly come to the next page, page 21. First, second, third paragraph. From the report of the SAE of this administration, it is revealed that the respondent has made G+6 storage construction over G+3 storage floor. That is, they have made 4th, 5th, and 6th floor construction without any sanction plan. But the learned advocate such and such, now you'll also kindly come to the skip the paragraph start regarding the other issue. Regarding the other further construction, G+6 floor over the G+3 floor building was unauthorized. It is made during the lockdown period with the waiting period of the sanction, as they have said to be deposited on 18th May 2020. They have deposited the sanction on 18th May. Now, you'll also kindly come to the first photograph, which is annexed at page 26. And initially, plan was G+3. And they have said that they have deposited this revised plan on 18 May 2020. Now, first photograph, you'll see dated 21st February 2020. It is stored 1, 2, 3, 4, 5. G+3. Admittedly, plan was submitted revised, so-called revised plan on 18th May. Photograph 21 May 2020. G+5. Now, you'll also.
Has G+6 been sanctioned?
Now, I'm coming to that one. By taking money, they have sanctioned the plan. Your lordship, that has also been recorded. Now, you'll also kind of come to page 21 once again. Regarding the other issue, I am reading page 21, last paragraph. Regarding the other issue of further construction of G+6 floor building over the G+3 is being unauthorized. It is made during the lockdown period with the waiting of the sanction plan, as they have said to be deposited on 18th May 2020, and they have started the same after waiting of 2 months. It is to be stated the provision of 207 of the Municipal Act, waiting of 2 months. If it be so, there is a provision under 207 of the Municipal Act 1992 to inform the attendant 60 days after receipt of the any application with the building plan or any intimation or document which is the Board of Council Administration acting on the behalf of the Board of the Council may reasonably require that the applicant or to furnish before the deciding whether the sanction has been accorded. Ultimately, my lord, they're taking the rupees 2 lakhs. They have regularized the plan, which is under challenge in the writ petition. After filing the writ petition, your lordship has passed an order on 18th January 2021.
Past order. What
On
is the order?
18 January 20, page 2022. Page 22. Page, you'll also kindly come to page 23 first. It starts from page 2022, page 23. The direction for filing affidavits. Now, I am reading 1, 2, 3, 4th paragraph. Respondent number 4 and 5 are restrained from carrying any construction in the premises in question in deviation of the sanction plan till 20th May 2021. It is dated, my lord, 18 January 2020. Order has been passed. Now, your lordship, kindly come to the photographs once again. 21. Your lordship has seen that before the plan is being submitted, they have raised G+5. Now, your lordship, next photograph. It is dated 12th February 2021. No, sorry, man. The third photograph. 16th May 2021. Photograph, this one. You also kindly see the function has been completed. Construction has been completed. Now, you also kindly come to the next. I have handed over the photograph, recent photograph as per direction of the honorable court.
Now it is G+6.
G+7. 1, 2, 3, 4, 5, 6, 7. One, two,
Check up.
3, 4, 5, 6, 7.
7.
1, 2, 3,
See,
4, 5,
that is
6,
the-
7.
1, 2,
G+6.
4,
G+6. G+6. And your lordship direction was not to raise any construction on and from 18 January. You also kindly see the photographs.
But in the meantime,
Yes, my lord.
the municipality has permitted construction up to the G+6 floor.
+6. By taking money, which is under challenge in the writ petition. Now, let's say, admittedly, they have submitted the plan on 18th May, prior there to G+5, without any plan. In the report, it is stated that the plan, the construction is being completed, construction is being raised without any violation of the sanction plan. This is their order. There is no.
Yes, Mrs. Maiti.
My lord, I have filed my opposition. Your lordship, kindly have a look to the opposition.
This is the opposition.
Tell me one thing, the construction was made during the period when the restraint order was there.
No, your lordship, nothing was left for further construction. This is my submission with your lordship. Before your lordship order was passed on 18 January 2021, Milord, the as per sanction plan, Milord, sanction was granted in favor of Milord 18th November 2021, Milord. November 2020, sorry, Milord, November 2020. And thereafter started construction. 18 November 2020, sanction was granted and thereafter construction was started and it has been concluded in the meantime. Before your lordship order was passed, Milord, nothing was left for further construction. This is to be submitted before your lordship, Milord, for your lordship's kind consideration. Regarding, Milord, other part of the, Milord, prayer of my learned friend, I shall place before your lordship. Your lordship, kindly have a look to the order once again, your lordship, kindly. Your lordship was pleased to pass an order on 18 January 2021. I shall place once again your lordship. Kindly see.
No, is it your submission that the order was passed by this court in January 2021?
My lord.
Who got the plan sanctioned in November 2021? So within November and December, G+6 story was concluded.
Outer, interior work was not done, but outer work was completed at that time, Milord. This is my submission. Your lordship, kindly have a look to your lordship's own order, page 78, your lordship.
The plan was regularized by the municipality in November 2020.
2020.
Order was passed by this court in January 2021.
Yes, Milord.
So within November, 11th of November and 18th of January, G+6 story was completed.
No, Milord. What I am submitting before is this, Milord. The case of the petitioner, Milord, containment number 1 and 2 is this, Milord. They have submitted their plan on 18th May 2020 and waited for 2 months. Thereafter, my lord, an appeal was prepared under section 208. And thereafter, my lord, they have started construction with information to the municipality, which is not reflected from the purported order passed by the municipal authorities on, my lord, after hearing the parties on 11th of November 2020. So, my lord, what I am on, my lord, construction was started prior to sanction, but it is not, my lord, yeah, it is admitted by the, my lord, consumer 2 and 3, my lord. But not that, my lord, without any information to the municipal authorities or, my lord, without taking any, my lord, permission from them. It is the submission of the consumer 2 and 3 is this, my lord. As per section 2207 of Municipal Act, my lord, they have submitted application, submitted their plan, and thereafter waited for 2 months, and thereafter another application was made on 21st July 2020 for sanction of grant of sanction of the building plan, and they are going to start construction work. That was the submission of the petitioner. That is on my part. Your lordship kindly have a look to the order passed by your lordship, passed by the Honorable Justice Compass Sarkar, at page 77.
That is the main issue in the writ petition.
Of my opposition, your lordship. I have a sub copy upon my learned friend. But no reply has yet been filed below.
My learned senior friend is proceeding with the writ petition.
What is
My
there?
lord,
in
your
the
lordship,
The writ petition was that initially
no.
I
I am placing page 77 to your lordship, my lord. Page 77
I
of
have
the
made
order
a-
passed by the Honorable Justice Compass Sarkar.
but I have filed a writ
Prior
petition.
application was made by my learned friend, and that was
Order has
disposed
been
of by
passed
Honorable
to
Justice Compass
consider my
Sarkar.
representation. In consideration of the writ petition and representation on 11th November 2020, they have passed an order. They have regularized the plan, taking the making the fine of 2 lakhs, which is under challenge in the writ petition. In the writ petition, your lordship has passed the order restraining the respondent not to raise any construction. I am showing even after 18 January 2021, they have raised the construction in violation of your lordship's order, and that
They
too, my lord.
strongly denied. They strongly
Prior
denied, and
thereto,
never it was
according to
done.
them, the plan was sanctioned on 11th November 2020. Even then, prior thereto, I have shown the photograph. In the month of May, they have raised the construction before making the application. They have made the application on 18th May. I have shown the photograph to your lordship. They have raised the construction G+5 on 21st February 2020.
Now, what is the challenge in the writ?
Challenge in the writ is the order dated 11th November 2020.
Regularizing the
Yes, regularizing. There is no,
plan.
I say that my petition is that there is no power on the municipality to regularize in construction. That is the under challenge before your lordship. That is to be decided.
Municipality has filed affidavit.
My lord, thing is that, my lord, previously Mr. Onamishikdar was appearing in this matter. And my lord, I find from the record that one opposition has been filed by the alleged contempt number 1, Mr. Madan Mohan De. But
In the contempt. That is in the contempt.
Contempt.
What about the main writ petition? Your power to regularize.
I have no copy of the writ petition, even my lord, the copy of the opposition filed by Mrs. Maiti. My lord, copy of the opposition of the contempt application, my lord, kindly.
We had served upon the earlier advocate Onami Shikdar, my lord. We have already served. But no new advocate has been Mr.
Yes, but then where are the documents?
Documents must be lying in this chamber.
Then those have to be collected, isn't it?
But I have so far the writ petition is concerned, I can hand over herein now. I have extra copy.
Writ petition is all right, but then if any opposition, your learned friend is saying that opposition has been filed by the erstwhile
Opposition?
advocate.
This is a opposition filed by the respondent, private respondent.
That is in the
Alleged
contempt.
number 2 and 3, my lord.
That is in the contempt.
Main writ petition also.
In writ petition also.
In a contempt as well as in the.
No, in the, yes, in the writ petition also, my lord, I have submitted my opposition.
So you need to obtain copies.
But I am having one copy of the application filed by the alleged contempt number 1 in contempt application.
No, I do not. The copy has been served.
So with this much of copy, the proceeding of the hearing cannot be done. So right now, what is to be done is the hearing of the writ petition and
So
see
for the contempt is concerned,
contempt
raising
is
of the
concerned.
construction.
Let us
even
see
after-
what can be done, because as of now, the construction is over.
Yes, ma'am.
Now, if the court decides that the regularization itself was impermissible,
As well, Lordship.
then
Your Lordship, kindly fix a date. I will hand over today itself. Tomorrow I will hand over all copies, whatever I have. There is a fix any date.
No, my lord, while the municipal authorities can pass the order, purported order, but they have overlooked the application under section 208 filed by the respondent number 2 and 3, my lord. That is kept pending. There is no whisper even that I have submitted an application under 208 of the Act, my lord.
The municipal doesn't have any record. They have said purported to be.
Yes, I have
been
annexed
said.
here with me, lord. I have
Let us
annexed
see,
here.
let your learned.
My lord, may I suggest one thing, my lord?
Yes.
At this juncture, I think, my lord, it would be wise decision to refer the matter before the municipality again. And under section 218, it is to be
There
heard
is a
out.
final order.
Cannot be, my lord will decide
no,
whether
madam.
any violation.
No.
There are some,
You do not have the copy of the writ petition. You do not know what is there.
my lord, that is true.
Contempt copy.
Contempt
Contempt copy annex on the final.
incomplete.
Contempt application arises out of an interim order passed by this court.
Contempt আছে তো
Stuff.
আমাকে তারা দেয়নি
Affidavit in the writ petition
page 20 দেখো page 20
have been filed by the respondents. Stuff. Let the
ওইটাই তো
writ petition be taken up for consideration. Stuff. The erstwhile learned advocate representing the municipality has unfortunately passed away. Stuff. The present learned advocate representing the municipality is not posted with all facts and the brief. Stuff. Let copy of the documents be handed over to the learned advocate representing the municipality. List the matter for hearing in the monthly list of December.
December
Because October it is not possible. Prior to the pujas, October, November, these 2 months.
instead of monthly list of December you'll also fix a date
It will go to the December only.
and it will also kindly fix a date
1st of December.
1st of December.
Acha, affidavit filed by the contempt by the private, which respondent?
Contempt number, my lord.
2 and 3. Contempt number 2 and 3.
2 and 3 in the contempt application
My
be
lord.
taken with the records. Affidavit of service filed in court is also taken on record.
And this will appear under the same heading application.
Same ending, application, it will be
Application.
hearing.
My lord, I have already also
yes.
filed, my lord, the
I have
affidavit in
to-
opposition to the writ petition.
Yes, that has been recorded.
And you
My lord,
let
your
the matter
lordship.
appear as my lord as 4 orders in that event, my lord.
I have not heard.
Also kindly let the matter appear as 4 orders. Your lordship has passed the order.
For orders, I specifically keep those matters for orders where hearing is complete. Maybe something little information is
Your lordship
required,
kindly-
it can be
My
disposed
lord,
of.
liberty may be given, my lord, if affidavit of opposition on my part has not been filed in the writ petition,
It has been filed, he says.
No, by the private respondent, not by the municipality.
Municipality has not filed.
then my lord, I'll file my.
The municipality is directed to file affidavit in opposition to the writ petition by 13th of
Is it?
October.
14th of October.
13th of October, 1-3. The petitioner will be entitled to file exception to the same by 24th of November. List on 1st of December. Under the heading for hearing.
My lord, may I be permitted to file the affidavit in opposition of the writ petition, my lord?
Yes, please. Affidavit in opposition to the writ petition filed by the private respondents is taken on record.
4 and 5.
Yes, they have, sir.
Reply.
And give me
Very well. Reply to the same may be filed by the petitioners by
the time.
same date.
Same date.
আগেকার রিপ্লাইটা যে ডেট আছে সেই ডেটটাই দিয়ে দিন।
And may I only pray one thing, my lord, if this matter gets some precedence, my lord. These are long pending issue, my lord.
Unauthorized construction.
Not
what
unauthorized,
is
my lord.
the-
Unauthorized, not at all the unauthorized, my lord.
Your lordship, I shall try to.
My house is beside
Your
that,
lordship, there
and
is no
they have raised
violation
the
at all.
construction. My house will at any day it will be collapsed. They have raised the construction in such a manner. I have stated everything. It will be collapsed. My house
Experts
I-
documents are there.
just beside the construction, my house is there, and
Yes.
it will be collapsed any day. The way
Why?
they have raised the construction in such a manner. I have annexed the photographs in the writ
No,
petition.
tell me where is the difficulty?
Difficulty
Are 2 houses there side by side?
side by side.
Then
They have raised the construction. You'll also kindly see the one photograph.
what is
they have-
there?
Specialist and not expert
Construction
opinion is
without
there.
digging the field, and they have raised the 7th floor construction which is sanctioned G+3, and my house will any day will be collapsed. This is the
Without their house collapsing, your house will
Now, if
collapse.
their house will collapse and it will fall on my house. That is the difficulty. That's why I'm saying, my lord. Give some precedent.
Municipality, please ensure if the foundation is there only of G+3, how can the
No.
construction of G+6 be permitted? This is extremely dangerous because what
Your lordship,
apprehension of the
will
petitioner
find
is,
for records. Your lordship will find from records.
untoward accident happens, then it will fall upon them because they are the adjacent owners.
Yeah, my lord, I have annexed the photograph.
No, my lord, from record.
My lord, your lordship will find from the records, my lord, that it was for G+6, my lord, not, my lord is not submitting, my lord, beyond records, contrary to records. G+6, it was filed.
Municipality,
You know,
please
that's
see
why I'm saying, my lord, your lord can
whether proper the mode and manner in which the construction ought to have been done for a G+6 story building, whether that has been done or not.
Initially, it was, my lord,
Do you
G+6.
follow?
That's why I'm saying, my lord, give some precedent. My lord, I have annexed the photograph.
Let us see. Let's pray that everything goes on well and no accident occurs in the meantime. Yes, call the next matter, please.
Okay.
I get deeply obliged to
I
you.
am for the petitioner, my lord. My lord, last occasion, my lord, directed to copy, sir, my lord. Already, sir.
Who is your other side?
My lord, contemner 1, my lord, Pradhan, my lord.
Pradhan, not appearing.
Order dated 23rd March 2021, my lord. Lordship, your order, my lord.
But in May, the service that you have made was in respect of the Pradhan who is presently not there. Possibly. A new incumbent has joined. Are you aware?
No, my lord, no have any instruction. So,
Yes?
no have any instruction, my lord.
It must have been the elections are just over. So you implead the new incumbent. Followed?
My lord, no have any instructions. So, my lord, kindly direction the next date I check.
I will give you time till next week.
Yes.
You take the name of the new incumbent and implead. Leave granted to the learned advocate on record of the petitioner to implead the present incumbent, Pradhan, Shankarpur-Roman 2 Gram Panchayat as party respondent in the contempt application and serve a notice upon the said contemner. Stop. List on 12th October. Affidavit of service filed in court is taken on record. None appears on behalf of the alleged contemner. ওটা করে দিন তো লিভ গ্রান্টেড যেটা বললাম না বাই নেক্সট শুক্রবার পর্যন্ত করে দিন 22 তারিখ How soon can you get the name? Madam, how soon can you get the name? Pradhan's name, you can always go and get it. Do it by next Thursday, 21 তারিখ. The next matter.
Well, this is my contempt application.
Well, first time it has appeared, this is unauthorized construction. Lordship direction was upon the
What is the date of the order?
Lordship's order dated page 15, 18th March 2021. 18th March 2021.
18th March 2021. Serve.
Yes, ma'am.
It is made returnable on the 23rd of November.
Well, 301, my lord, this is an application in connection with a review.
Are you the review applicant?
Yes, I'm the review.
Who are the respondents?
My lord, I have served, my lord, the learned advocate who is appearing in the before your lordship, as well as, my lord, the learned government pleader.
Who is the learned advocate?
Mr. Parthopotim Rai,
He is appearing for the state,
writ petitioner.
for the writ petitioner. What was your status in the?
My lord, in the writ petition, my lord, I was impleaded as a private respondent, but my lord, unfortunately, my lord, I did not appear. An order was passed. My lord, kindly remember, this is a matter pertains to auction of a ferry ghat. Now, my lord, I was a successful bidder, and my lord, a contract was executed between, my lord, the private respondent and the state. Now, my lord, a writ petition come up before your lordship saying that though the writ petitioner want to pay more my lord, amount than the private respondent, but he was not allowed to participate in the tender process. And your lordship was pleased to pass an order directing, my lord, the executive engineer of the respondent that in the case, if, my lord, the writ petitioner want to pay more amount, then he shall be considered as a successful bidder. Pursuant to that, my lord, this the writ petitioner was allowed to my lord, the tender, and my lord, my tender, whatever, and the contract, what was concluded, my lord, between, my lord, the state and the private respondent, that were terminated. Challenging that, I come up before this honorable court. This honorable court, my lord, after, my lord, a considerable, my lord, after giving the opportunity of affidavits and after hearing, well, the court find that the only remedy is to file a review application, because this, since, my lord, this order has been passed by a coordinate bench. So, my lord, I preferred a review application, and, my lord, this is a review, my lord, but meanwhile, what happened, my lord, this period of contract is over.
So what remains?
Now, the remains is my contention is that, as per, my lord, I am equipped with the decision of the Honorable Supreme Court that in case of a concluded contract, when there is no element of fraud, the contract can be terminated by payment of compensation. My lord, it's not a case that I am only getting a tender and, my lord, paying some money to the authority. For the purpose of running this ferry ghat, I have invested at least 10 lakhs rupees. Now, my lord, the question, I put a question to myself, my lord, who will compensate me? Since, my lord, from the order of your lordship, it appears that there is a mistake in the process of the state. I am not involved in any way with regard to the process, because as this process is, if, my lord, someone bids an amount and the second one is not bidding the more amount than the first one, he will not be allowed to bid. So this is the process of the state. I am not at all concerned with this. I am a second bidder. First bidder is not accepting. So, my lord, I put a question to myself, my lord, who will compensate, my lord, the private respondent? And this is the, my lord, this review application is meant for.
Compensation.
Yes, my lord, because it is a state fault, my lord. I am not at all, my lord, defaulter in any manner. This is a concluded contract.
Is the contract valid for only 1 year?
1 year.
And fresh contract?
My lord, my instruction is this year the auction has not yet been started, and this the writ petitioner is still running this ferry ghat.
And when was the last date of the contract?
My lord, this contract probably ends in the month of July.
July.
Because, my contract
Now, suppose you participate in the next auction notice and you become the highest bidder. Then you will enjoy
I can
whatever-
utilize my equipments. But
Yes.
if Lordship, I have annexed all the receipt that I have purchased a ferry for this purpose. 2 ferries. There are the renovation of ghat
But
and
then you
everything.
can always use the ferry for some other.
No, I can't. Because
not?
the ferry because this ferry ghat, for running the ferry in a particular ferry ghat, I have to take the license. I have to participate because this is a licensed ferry ghat,
Where license
I
is
can
not
use the ferry
required.
for fishing purpose. That's a different issue.
For any other purpose also you can use for commercial purpose.
For commercial purpose, I have to take the license.
You can lease out the ferry to somebody else. You can rent it out for somebody else.
But
This can be done.
But the difficulty is, I have annexed all the bills that I have spent more than 10 lakhs rupees for this purpose.
Please come. An application for review has been filed.
My lord's order is page 32.
Seeking review of the order passed by this court on 13th July 2022. Stuff. The matter related to a public auction conducted by the Murshidabad Jiaganj Panchayat Committee. Stop. Next. It has been submitted by the learned advocate representing the review applicant that the contract of the ferry has expired in the month of August 2023.
No, I'm sorry, it's expired in that June 2023.
Actually, June 2023. Stop. The Murshidabad municipality, the Murshidabad Jiaganj Panchayat Samiti is liable to conduct fresh auction. Stop. Paragraph. The review applicant submits that that he suffered huge financial loss on account of the error on the part of the government officials, especially the BDO.
BDO, my lord.
Block Development Officer.
Yes.
Murshidabad Jiaganj Block. Stop. The petitioner invested quite a considerable sum for making the ferry ready, for renovation of the ghat. Stop. The Panchayat Samiti illegally and arbitrarily terminated the contract of the review applicant. Stop. Next. The petitioner seeks compensation on account of the losses suffered by him.
This is the authority, my lord, on the basis.
Wait. It appears that the petitioner is yet to raise any demand before the block development officer seeking compensation on account of the losses suffered by him. Stop. It will be open for the review applicant to file appropriate representation before the block development officer, along with all records in support of his claim of suffering huge loss. Stop. Next. In the event such representation is filed, the same shall be considered by the block development officer in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order within a period of 8 weeks from the date of receipt of the representation. Stop. A reasoned order shall be passed and communicated to all the parties. Stop. Next. the petitioner will be permitted to participate in the future auction process, provided he is eligible for the same. The review application stands disposed of.
Grateful, my lord. The next one is also same matter, my lord.
And the order date is also same.
Yes, same.
Next one, same order. All connected applications.
Only the ghat is
disposed of.
different. The Panchayat Samiti is also same.
Same.
Great.
My lord, I am for the petitioner. My lord, matter is pending before the matter is pending before the apex court, my lord.
Apex Court. It has been submitted by the learned advocate representing the petitioner that the matter is pending consideration before the Honorable Supreme Court of India. Stop. In view of such submission, let the matter be delisted for the time being. Stop. Liberty to mention.
4 weeks. 4 weeks time.
Liberty to mention. Even it is within 2 weeks, come.
My lord, maybe, my lord, within 4 weeks, my lord. My lord, kindly.
Next matter.
Lordship, item number 303, Lordship, I am appearing for the alleged matter numbers. Lordship, may I please hand over the order
Order of?
of the Honorable Apex Court, Lordship.
Let me see.
Lordship, system around it.
Reply already filed. Reply has been filed, my lord.
Very well. This was in July 23. Let it be heard. You mentioned liberty to mention. Keep this on record. Review. The order dated 24 July 2023, passed by the Honorable Supreme Court of India, be written with the records.
Nah, Mr. Formal appearance. I
304.
304. 304. 304 is a review application.
Review application, my lord, I am appearing for the applicant.
Review applicant.
Lord, I am opposing the review application.
Led by Mr. Colonel Basu.
Lord, on last 3 occasions, Lord, the accommodation was sought for on behalf of Mr. Basu. Yes, Lord.
No, he is not paying accommodation.
Oh.
Yes, what is the matter?
Lordship.
Lord, I will be taking the
Application has
point
been
of
prepared.
maintainability first. Let him please.
Let me see the file.
My lord, your lordship will kindly recollect, my lord, it is that matter where your lordship was pleased to dismiss the writ petition by imposing a cost of rupees 25,000 on the writ petitioner. The order has been complied with. And your lordship was pleased to record that almost 192 writ petitions was
Pradeep.
filed by the same person.
Pradeep.
Their allegation is wrong, Miller. Such
Who are
number has
you?
not been.
Who are you?
I'm for the applicant petition.
Review applicant, is the
Review
writ petitioner?
Lordship.
Yes.
Lordship, their allegation was that 192 cases has been filed by me against them, writ petitions. That is a wrong submission. That has not been filed by
And
me.
you are seeking review of which order?
My lord, the
Review
order dated
of
my lord,
the order.
22nd September 2022.
Let him speak. Wait, late. 22nd of September. Did you prefer any appeal against this order?
No. I
Did
prefer
anybody else?
review because I find some error apparent from the record. This is my main point. Because factual aspect has not been placed before your lordship in a proper manner. This is my submission. And I want to submit those documents which has not been placed before your lordship at the time of the adjudication of the writ petition. Those matters are on record. Lordship has recorded, but somehow it has been overlooked.
The cost has been deposited.
Yes.
Lordship.
How are you aggrieved with this order?
Lordship, I have been aggrieved because this order has been relied upon by the Honorable Chief Justice also in a separate case. They cited the case, this order of this Honorable Court before the division bench of Honorable Chief Justice, and Lordship has also relied on
That is the reason which prompted you to file the review.
Not only that, Miller, this order has a impact of at a large, Miller. This order,
Your client is involved with large matters.
Lordship, then he is public spirited person, and he is involved in separate cases, several cases relating to public interest litigations and illegal constructions of the localities. He involved in separate cases, several cases, in separate manners. Therefore,
What is the error apparent on the face of record?
Lordship, firstly, the 19 Lordship's order is under memo of review. The second page of your lordship's order, list has been placed before this court containing details of 195 cases filed by the petitioner before this court, primarily challenging the action on the part of the respondent. 195 cases has not been filed by me. That is not by me. They submitted.
Who has filed this 195 cases?
I do not know, but I have not.
May I tell your lordship only one
The
thing?
private respondents are involved in several illegal construction matters. The whole complex has been made up on a government wasted land. Land was involved in refugee, refugee land. It was refugee land, my lord.
সুব্রত রিট পিটিশনের কপি আছে?
Petition is in my application, my lord. The annexer R1, page number 37.
The list of 195 cases, did you produce?
Yes, I had. The private respondent produced with your lordship. Your lordship is pleased to see and record on the,
And that has been returned.
that has been returned to the landed
That is
advocate.
not there in the file.
My lord, may I tell your lordship only
That
one
has
thing?
been
Your lordship will
No,
find,
it's
taken
there.
on record.
Sorry, it's there.
it was filed by the private respondent.
Biplab Kumar Chaudhary. 195 cases not filed by you.
Not filed by me, my lord.
My
This is from the High Court site.
Yes.
I shall, if not 195.
My lord, it may not be 192, it may be 182, it may be 172, whatever it is. My lord, your lordship was pleased to dismiss other applications of several writ petitioners by
Lordship, I have not
recording that
applied
there is an unholy nexus.
I have not looked at the list, my lord.
You know the matters that you have filed. And this is obtained from the official site of
Website.
the High Court.
I have filed several cases.
Yes, you have filed several cases and this is what has been handed over to the court and has been recorded.
Yes.
Now, Millard, question is, Millard, whether it amounts to the abuse of process of court, Millard, number one. The court has not come to a finding, Millard, that by evidence, Millard, there is no affidavit, that these are the cases, Millard, where, Millard, the record shows, Millard, that we have filed, Millard, cases. But question is, Millard, there was no consideration. And the list was never supplied to us, Millard. Kindly.
The list is from the official
Official
website.
but what are the subject matter of the list? What are the, Millard, the ingredients in the, Millard, whether there any element which inspires the confidence of the court, or, Millard, the successive litigation?
95
Millard,
petitions.
Millard, I tell your lordship, Millard,
And
only one indulgence, Millard. That
most of them are.
no, Millard, I kindly give me a chance to, Millard, deal with each and every one cases why I have filed. If your lordship finds that yes, that the every case is, Millard, absolutely a repetition of the earlier one, Millard, whatever.
Repetitions. But then what has
Millard,
been
there is
submitted?
no, Millard, kindly says that the number of the, Millard, kindly give me a chance, because the respondent has not come with a specific case, that all cases one after another, Millard, all the successive litigation, Millard, is mere replica of the other. Otherwise, Millard, suppose, Millard, I have, Millard, I am a public, no, it is not a case before your lordship that by dint of filing these severe cases that I have blackmailed someone, that it is an extortion.
Exactly the case.
That is exactly the case, but there was no investigation, no charge sheet.
No, that is different.
No, I tell your lordship, Millard, there is no, Millard, absolutely, Millard, your lordship is right, that if I have filed, Millard, several cases, Millard, but the question is, the issue is of public importance. It is, Millard, suppose, Millard, I say that the water body, the removal of water body, Millard, ecological balance, illegal construction, which disturb the mind of the court. Many a times your lordship, Millard, became merciless and, Millard, directed that the illegal structure to be demolished. No compromise, no tolerance. Now, Millard, in this matter, if I have found that in the Damdam municipality, within this, the municipality has indulged. Now, whether without any investigation or any report.
Come up with a better case, we will see. This is not a case where review is to be allowed.
No, Millard, only one thing, Millard.
No, nothing.
Millard, it is one of the cases.
But
rather,
cost has
where
been imposed, Millard,
Honorable
50,000.
Chief Justice imposed
Only,
a
Millard,
further cost
Millard,
of
cost.
50,000 rupees on them, and that has also been complied with.
Please come. Please come.
There is no ground for review at all.
The petitioner seeks review.
Millard, only my junior wants me to show your lordship, Millard, that this particular page, page 7 of the supplementary affidavit, Millard, it clearly says, Millard.
Supplementary affidavit.
Review of the order
petition.
dated 29th September 2020.
It was taken on record.
Stop. it appears that the writ petition stood dismissed on the said date upon imposition of cost. Stop. The costs have been paid by the petitioner. Stop. Next. The petitioner submits that the said writ petition stood disposed of without granting proper opportunity to the petitioner to controvert the allegation made against him on the said date. Stop. Next. It appears that the court relied upon the information provided by the learned advocate representing the private respondent, which was a list obtained from the official website of this court, containing the details of 195 cases
Not against the same person, my lord, but against the different persons.
195 cases where the petitioner, in most of which the instant review applicant is the petitioner, and in a couple of the matters, he is the respondent. Stop. Next. The grounds made out in the review application are not entertainable. Stop. Next. In the event the petitioner is aggrieved by the order, the petitioner may seek remedy before the appropriate forum. Stop. The instant review petition cannot be admitted. The same hereby fails and is dismissed.
Deeply obliged, my lord. I'm grateful, dear lord.
Thursday. None appears on behalf of the petitioner at the time of call. No accommodation sought. Contempt application stands dismissed for default.
Lordship, I am for your petitioner.
And I'm appealing for the alleged contempt.
Lordship, copy is served, affidavit of service.
Has the order been complied?
Not Lordship.
No.
No. Lordship, order dated 5th of March 2021.
Very well. Yes.
I'm submitting, my lord. My lord, on 5th of March 2021, my lord, your lordship was pleased to direct the municipality to demolish the unauthorized construction, my lord. Thereafter, on 19th January 2022, my lord, the private
Appeal
respondent
was-
challenging, yes, my lord, appeal was preferred and that was subsequently dismissed, my lord. Thereafter, my lord, on 24th March 2022, the chairman of the municipality issued a notice for demolition. Challenging that notice, my lord, the private respondent preferred and municipal appeal, my lord. And the private respondent got a stay, my lord. Subsequently, that appeal was dismissed for default, my lord. Thereafter, my lord, the municipality issued a notice on 15th June 2023, my lord. And challenging that notice, the private respondent again preferred an appeal, my lord. And in spite of that, my lord, the officers of the municipality, my lord, went to the premises, my lord, and tried to demolish, my lord. But the flat owners of the construction, my lord, they said, my lord, that they had no knowledge about the demolition order, and they restrained the officers of the municipality, my lord, and wrote a letter, my lord, to the chairman of the municipality not to demolish. Thereafter, my lord, the flat owners moved a writ petition before your lordships, and which is pending, my lord, item number 1726 of the monthly list, my lord. That's why, my lord, the municipal.
And is the order of dismissal of the suit that was filed, has any order been passed recalling the order of dismissal?
No.
So the suit is no longer there, it is dismissed.
Yes, madam. Dismissed for default.
Default, but then
Yes.
it is dismissed.
But, subsequently, it has no, perhaps it has not yet been restored, madam. The
You are
municipality
not aware whether it has been restored
no,
or
no
not.
information.
And give me the number, writ petition number.
Writ petition number, my lord, WPA 15679 of 2023.
15679, which is the item number. Pradeep, find out this brief.
1726 of monthly list.
Very well, you give notice, it will appear together.
Lordship.
The petitioner complains that the order passed by the court has not been complied with till date. Stop. Learned advocate representing the municipality submits that a writ petition is pending consideration before this court in respect of the same construction. Stop. Let the writ petition being WPA 15679 of 2023 appear in the list along with the instant contempt application on 28th September 2023. Stop. Let notice be served upon the learned advocate representing the petitioner in the writ petition regarding the next date of hearing. Are you aware of the writ petition?
No, Lordship.
You are not aware?
No, Lordship.
You have seen the number?
Lordship. Yes.
Intimate, come.
Petitioner led by Mr. Ismail.
307, my lord, I am appearing for alias contempt. My lord, in this matter, I have filed my application to the SLP. SLP grant G20 held on in Delhi. So all the matter, my lord, supposed to struck down, and next day, my lord, supposed to hear out. So that's why, my lord, I am praying for at least 2 weeks time.
Please come. A special leave petition over the same issue is pending consideration before the Honorable Supreme Court of India. Stop. Learned advocate representing the alleged contemner seeks adjournment of the matter. Stop. Next. In view of such submission, the contempt application stands adjourned till 23rd November 2023.
And 319 identical matter, my lord. Both are same matter, my lord.
319.
319, my lord.
You are
Same
there?
petition.
Same order will go down in 319.
Deeply obliged, my lord.
This is my application, 300.
Lordship, I appear for the English Bazar municipality. English Bazar municipal.
Lord, they had filed a compliance report, but I'm filing my exception to that.
Yes. Order has not been complied.
My lord, a reasoned order has been passed, my lord. But that, my lord, I had pointed out from the reasoned order that in effect, my lord, sits in appeal over your lordship's order. And therefore, my lord, in my humble submission, it's not a compliance of your lordship's order. If your lordship is kindly pleased to take the exception that I have filed, I have also, my lord, quoted the relevant portions so that back and forth we need not go to the documents. Kindly take paragraph 5.
Yes.
Towards the, kindly takes from the 5th last line onwards. And meaning. Actual purport and meaning. Page 2, paragraph 5. 1, 2, 3, 4, 5. 5th line I am reading, my lord. Actual purport and meaning of the judgment and order dated 19 February 2021, passed by Her Ladyship, the Honorable Justice AMRITA SINHA, wherein it was directed that it appears from the order of the chairman that he has proceeded in a manner on a matter in a completely different premise. The court directed the chairman to consider the representation of the petitioner. The representation of the petitioner was with regard to violation of the provisions of Rule 50 of the West Bengal Municipal Building Rules 2007. The same does not have any relation with their mutation, with either mutation or the pending case under Section 147 CRPC. The chairman of the municipality, this part is very important. The chairman of the municipality was required to inspect the property and come to a specific finding whether the mandatory open spaces as prescribed in Rule 50 of the aforesaid rules has been maintained by the private respondents at the time of making the construction. The same has not been done. The chairman ought to have appreciated that mutation of the property and the proceeding pending before the court below does not have any bearing with regard to the unauthorized construction being made in the said premises. Accordingly, the impugned order dated so-and-so passed by so-and-so is set aside. The matter is remanded back to chairman to take steps strictly in accordance with the direction passed by this court on 25th of September 2019, which is the erstwhile writ petition passed by my Lord Justice Shwapti Chatterjee, which was also not complied with by them. Within a period of 6 weeks from the date of communication of the copy of this order after giving opportunity of hearing so-and-so. Then, after the quotation I am placing, the Honorable Court had exactly pointed out the loopholes on the part of the private respondents and the alleged contemner, but the alleged contemner has instead passed and reasoned order dated 15 February 2023, which is dehorsed the order and judgment and order dated 19 February 2021, passed by Her Ladyship, and has not even conducted an inspection report with the reasoned order showing the exact measurements of the premises, and has merely written an essay in the name of the reasoned order to safeguard its blue-eyed boy, that is the private respondent. In the process, the alleged contemner has feigned ignorance towards the inquiry report passed by the municipality regarding the unauthorized construction of the private respondent dated 12th of July 2019. This is at page 48 of the contempt application, earlier inspection, wherein it has been specifically stated that, quote, during inspection, few irregularities are found according with the sanction plan on dated 26th April 2018, vide permission number so-and-so. During measurement, it appears that in eastern side, there is no side clearance. In southern side, 1 feet side clearance. In western side, 1.6 feet side clearance. In northern side, 6 feet side clearance. In western side, there is a window measuring so-and-so in ground floor. So-and-so in first floor, so-and-so in second floor, so-and-so in third floor, in place of so-and-so, 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 and so-and-so respectively. This is their own finding. And my lord, in the earlier order also passed by your lordship, which is in the contempt application at page 72, your lordship directed them to inspect the property in terms of the order passed by my Lord Justice Chatterjee, as Her Ladyship then was. My lord, instead of that, kindly take their compliance report at page 4. The reasoned order is annexed. Kindly takes page 5 onwards. Page 5, my lord, last paragraph I am placing. It appears that both the complaints made by Dr. Anita Das have duly been attained and necessary measurement was taken by the authority in consonance with the sanction plan passed by the English Bazar municipality. The measurements has been conducted by the engineers of this municipality dated 22nd December 2021, and it is found that there is no deviation at the side of the petitioner, Dr. Anita Das. Kindly see how he's avoiding the issue at the side of Dr. Anita Das, meaning only one side. With the past sanction plan, rather the opposite party, Dr. Ranbir Bose, left more space than the sanction plan at the side of the house of Dr. Anita Das. The file or case record is opened after receiving of the solemn order of the Honorable High Court, Calcutta, dated 9 February 23, wherein the Honorable High Court, Calcutta, has been pleased to give a direction for passing final order. This is in the contempt. This order is in the contempt. On perusal of the entire proceeding, now important, it reveals that there is no need for further measurement, as the same had been done and no deviation was found in the construction of Dr. Bose from the sanction plan at the side of Anita Das. So, my lord, after your lordship directed that an inspection has to be conducted, he sits in appeal over your lordship's order and says no inspection is required. And he relies on an inspection carried out in the interegnum, which he very carefully worded way says that there is no deviation at the side of Dr. Anita Das. And the entire issue of Rule 50 of the building rules, which my lord kindly takes the inspection report, it is their own inspection report, that is at page 48 of my contempt application. Their own assistant engineer had conducted that. Sub-assistant engineer, my lord, at page 48, clearly said there's a deviation. That was my case from the beginning. From the first round of litigation, my lord Justice Chatterjee looked into it, asked them to pass a reasoned order. Then they passed a reasoned order saying that I have not mutated my property, proceeding under 147 CRPC.
Why was your client absent in the hearing?
I'll tell your lordship, my lord. Initially, I was called for hearing. I went there. Thereafter, my lord, year after year, it was left pending. My lord, my client, my lord, is a professional doctor. My lord, at the whims and fancies of the chairman, keeping it pending for 2 years, my lord, the order, my lord, under contempt is 2021. This order is passed. Kindly seize the date after the contempt application is filed, as if the chairman is saying, as if by way of February 2023's order is passing the final order. This final order is passed in February 23. After 2 years, initially I went for hearing. Thereafter, nothing. I kept on giving representations. They were not moving. In the contempt application also, they came and said there is no reasoned order. Then your lordship passed an order. That also I have quoted in my exception. Kindly takes. That is quoted at paragraph 6 of my exception. I am reading it for your lordship convenience.
No, it's all right.
Now, time to comply the order passed by the court expired long back.
What is your submission? Lordship, in this matter, Mrs. Sonal Sinha is appearing in this. She has been instructed me to take some adjournment due to she could not come to the court due to her some personal problem. But then this chairman is required to appear before this court. Please come. Exception by the petitioner to the affidavit of compliance filed by the chairman, English Bazaar municipality is taken on record. Stop. It appears from the order dated 15th of February 2023, passed by the chairman, that he has come to a finding that there is no need for further measurement, as the same has been done and no deviation was found in the construction. Stop. Next. The court where is the order for fresh inspection?
My lord, that is at page 72 of my contempt application.
72.
And my lord, your lordship will find the relevant portion at page 74, second paragraph towards the middle. The sentence starting after section 147 CRPC.
The court by order dated 19th February 2021 specifically directed the chairman of the municipality to inspect the property and come to a specific finding whether the mandatory open spaces as prescribed in Rule 50 has been maintained by the private respondent at the time of making construction. Stop. Paragraph, there is no answer to the direction passed by the court. Stop. On the contrary, the chairman has passed order that fresh inspection is not required. Stop. The action of the alleged contemner is contrary to the direction passed by the court. Stop. Next. The court accordingly directs the chairman, English Bazaar Municipality, to remain personally present in court on 28th of September 2023 at 2 p.m.
Grateful, my lord.
Directed me to appear in this matter on behalf of the Commissioner of School and take approval already made.
Well,
An appointment letter.
appointment already given by the day.
Has been complied, Your Lordship.
Lordship order already complied, madam.
It is only because you came in the picture that the order has been complied. Please come.
Only request my lordship regularize by appointment.
Yes, certainly. I will be very happy. Please come. Learned advocate representing the respective parties submits upon instruction that the order passed by the court has duly been complied. Stop. In view of the above, there is no requirement of proceeding with the contempt application any further. Stop. The contempt application stands disposed of. Stop. Next. The learned government pleader is requested to regularize the engagement of Mr. Pantu Debroy, learned AGP, along with same junior in all the matters, or there are other juniors? Same junior. Please give the name. As respondents representing the state.
Chief Justice.
3092
13 till 30, up to 13. Your Lordship.
09 to 13, same order.
Deeply obliged.
Please enter your appearance.
Instruction kept on record.
Yes, the instruction handed over in court today be retained with the records. You have got different instructions in all the matters.
No, all the same.
One instruction in all matters.
One is the same.
Well, already appointed, madam.
Already appointed.
Very well. Enter your appearance.
Yes, ma'am.
This is my lord, with regard to item of 340, my lord, order has been complied with. What is directed?
1 minute, let the files be sorted out. Your lordship was 1 minute. Yes, you are there.
Lordship, your lordship was pleased to direct in 15 June to serve upon the container, lordship. I have served, lordship. This is my affidavit of service, lordship.
Has the order been complied?
Lordship, not.
Second page of the order.
Your learned senior friend says it has been complied.
Lordship, the PRDO says that
Directed reason order be passed. The reason order be passed, lordship.
Reason order passed.
Lordship, your lordship directed him to consider his prayer, lordship.
And that has been rejected.
Lordship, may I? Lordship, this order was passed, my lord. Kindly see the operating portion, my lord.
Yes.
My lord, the observation. May I read, my lord? Heard the petitioner Sri Lokhikanto Ghoshal in the instant case as well as from concerned district and block authorities all length. After careful perusal of the relevant documents in the instant case, it appears that the petitioner Sri Lokhikanto Ghoshal was engaged.
I'll give you leave to challenge this.
Lordship, he is applying before the concerned authority and praying before your lordship for a sanction post of a video of an orderly, my lord. His prayer was rejected by an ambulance driver, lordship.
Challenge this. Challenge this. Please come. Order passed by the additional secretary, comma, Panchayat and Rural Development Department, dated 20th of July 2023, is placed before this court. Stop. It appears therefrom that the prayer of the petitioner for regularization has been rejected. Is it for regularization or
Lordship,
appointment?
It is for appointment, lordship.
Oh,
All-
appointment.
My lord, one more sentence, my lord. My lord, all the videos concern him as a orderly, my lord, not the ambulance driver.
Has been rejected. Stop. The petitioner is aggrieved by the same. Stop. Next. I'm afraid that the contents of the order passed by the additional secretary cannot be gone into in the contempt application. Stop. It will be open for the petitioner to challenge the same in a fresh proceeding before the appropriate forum in accordance with law if so advised. Stop. The contempt application stands disposed of. The order dated 20th July 2023 be retained with the records. Affidavit of service taken on record.
Yes, my lord, I am for the petitioner, my lord, but the operating part of the last order, my lord, kindly
My lord,
consider.
I have already sent to the Commissioner of School Education for the approval, my lord, pending for approval, my lord, I filed the complaint. I'm paying for 3 weeks time for
How many times?
3 weeks, my lord.
3
Pending
weeks?
for approval of the Commissioner of School Education.
But then you are not appearing for the Commissioner of School
I'm appearing
Education.
for District Primary School Council. my lord.
Yes, when did you forward?
My lord, Commissioner of School Education on 8th September 2023 issued a memo for requiring some papers, my lord. That's why, my lord.
In the last occasion, they prayed for fortnight adjournment. Lordship was pleased to 6 weeks.
Already.
Then a long period, 15th June. Order was
2023, my lord. Primary School Council.
Is the Commissioner also party over here?
Yes, my lord.
That's right.
Who is appearing? Supriyo Chattopadhyay, Mr. Devroy. Mr. Supriyo Chattopadhyay is appearing. See, he's not here.
Yes, my lord, today.
He is ill.
Yes, my lord.
What has happened?
High pressure.
High pressure.
He is irregular, my lord.
Yes, my lord, in the writ petition, the respondent number 3 is the commissioner.
No, in the contempt application.
Yes, my lord, page 4, my lord. Kindly see page 4 application. Yes.
No, the
Contempt
commissioner is not a party.
No, but the direction upon the chairman and secretary, now I cannot make the party.
Wait.
But your lordship knows that the
Wait. You found the certificate given by the petitioner as genuine. It is genuine certificate.
Already sent to the Commissioner of School Education for approval, my lord. Pending
So
for-
why will this candidate wait?
This matter was dissatisfaction of lordship's order. Matter was going to the appeal court. Appeal court dismissed lordship's order upon. Thereafter, my lord, contempt application.
The petitioner is wanting a job.
Yes.
Have you followed? If he does not get the job and if he is entitled to get the job, then he is losing valuable years in service. Who is going to compensate the petitioner? You are not going to come and compensate the petitioner. Will you? You will not. Now, what is the age of the petitioner? You will see that he is age barred. Then you will say that you will not give him the appointment. All these things will come. Then your already sending will not do. You have to follow it up because this is under the court's direction you are acting. You cannot afford to be so lax. Please come. An affidavit of compliance has been filed by the chairman, North 24 Parganas District Primary School Council.
No copy has been served to me.
Give a copy, please. Wherefrom it appears that the chairman has treated the petitioner as scheduled tribe candidate. Now, the chairman has forwarded the relevant documents of the petitioner to the Commissioner of School Education for approval of appointment or for necessary instruction for further course of action. Stop. Next. It appears that despite the order passed by this court, duly affirmed by the Honorable Division Bench, the chairman has forwarded documents to the commissioner seeking necessary instruction for further course of action. Stop. The only course of action required to be taken by the chairman is to take necessary consequential steps for issuance of the appointment letter in favor of the petitioner. Stop. Next. Paragraph. It is high time that the order passed by this court is complied with. Stop. The matter is peremptorily adjourned till 5th of October 2023. Stop. The appointment letter of the petitioner, if not issued by the said date, the chairman, North 24 Parganas District Primary School Council shall remain personally present in court at 2 p.m. Have you followed the order? If the appointment letter is issued, well and good. If it is not, the chairman will remain present in court. And from here, he'll be sent to custody. Make this very sure. Yes.
Obliged, ma'am.
Next matter, what has happened?
For 1 to 5. So here, my lord, only Jila Parishad is concerned. Lordship, instead of that, my lordship will direct this for number 8, container number 8 to take step. Otherwise, not this. They are worker of the employee of the Jila Parishad. The lordship order was the Jila Parishad, other
benefit given to other person, so he can be considered chairperson. The entire thing done by the Jela Police. So Lordship kindly, my lord. It's for no 6, and 8, execute level. 8, 6. 6. Guy of 6 by 8. Jela Police is main.
But then part compliance has been made, and in view of the order passed by the additional executive officer of the Purulia Jela Parishad, the rest cannot be complied with.
Given some time to comply with the order.
No, time was given in February 2023.
Oh, my lord, I'm not appearing.
Yes, that is the reason your presence was required. In June 2023, you came in, but then still now it has not been complied. What is to be done?
They have not calculated the area field date.
Calculation of area amount,
Executive officer,
service, retirement benefit.
they are up to date benefit, ma'am. Subsequently, they have regularized, ma'am, and then granted the notional benefit.
Notional benefit is to be calculated.
Ma'am.
And who is not calculating it?
That executive officer Jila Parishad, the concerned authority of Jila Parishad. They will calculate it and send to the concerned authority.
Mr. Debroy, executive officer of the Jila Parishad is not acting.
Lordship can direct the executive officer.
No, that direction is already there. How many times direction will be given?
Lordship can adjourn for some time. Executive officer তো SDO বোধহয় নাকি? DM নিজেই আছেন।
Who is the executive officer?
District magistrate. Again, Panchayat department is concerned, nothing to do. Jila Parishad only.
Whatever, if the DM is there, then you can always act.
Sir, definitely. Definitely I can act. My lord, order, madam.
লিখুন তো, the district magistrate. Which district? Purulia. Being the executive officer of the Purulia Jela Parishad. Is he a contemner? What is his name?
Rajot Nanda. Agently কি চেঞ্জ হয়ে গেছে তার কোনো কিছু।
Like, but the information presently he is there.
Who was the earlier one?
Rajot Nanda is the petitioner, contempt petitioner. Some changes are here the day before yesterday.
Acha, the কি বললাম, the district magistrate Purulia being the
only mention the district magistrate. That is
he is the executive officer, chief executive officer. Chief executive officer of the Jila Parishad is directed to take steps for compliance of the direction passed by this court on 20th December 2020, 22nd December 2020, 22 tarikh. Stop. Calculation of notional benefit is required to be made. Stop. The aforesaid officer is directed to take positive steps in the matter and ensure that the order passed by the court is complied with. Stop. List on 12th October 2023, an affidavit of compliance be filed on the adjourned date.
It will be done.
Please, I know with your cooperation, it will certainly be done.
Regarding item
Only 3 days, my lord, director, commissioner written that letter.
Yes, they can do it within 1 day also.
Immediately come to me.
You show them the stick, they will work. Without that, they don't. This is the sad part. Yes.
regarding item number 307 and 319, your lordship fix them at 23rd of November.
307.
7 and 319. Since the
319.
matter is
Huh.
pending before the Honorable Supreme Court,
Supreme Court.
tomorrow is the date.
Tomorrow is the date.
If something happens tomorrow, then can you
Mention.
give liberty? I shall mention it.
Mention.
That is a
Very well. Please mention.
Get much of this.